Yes, sorry for the delay. Yes,
Okay.
mention.
I said mentioning.
Let me have leave to mention the section 11 application, my lord. My lord, the affidavits are complete, maybe included any day for him.
Last heard on.
My lord, last hold on. 30th of September 2022.
Mention the last week of September. Yes.
My lord, may I be permitted to mention, my lord, an execution application, my lord, which was last heard on 13th January 2023, and my lord, it was made returnable after 8 weeks, my lord. Since then, I've mentioned twice, my lord, that asked me to mention. I mentioned last on 2nd August 2020.
Yes, last week of September. List good.
Much obliged.
May I have your lord's leave to mention the matter? My lord, this is a section 9 application. This is appearing in your lordship's list today as section 15 in the non-commercial division.
As section 15.
Item 15 in your lordship's non-commercial division matters. I was praying for an extension of the interim order which expires today.
Yes, to be mentioned tomorrow.
Very well, your lordship. Grateful.
Yes, if it's not called on. It's item number.
15.
You don't think it's going to be called on?
Your lordship, in case it doesn't call,
Yes,
get
so
called,
in case
kindly
it's not
gives
called
liberty
on, then you have to mention later on.
Very well, your lordship.
My lord, may I be permitted to mention a new section 9, my lord? For its urgency, we mentioned it before Honorable Justice Kapoor, but his lordship didn't allow the mentioning. So I'm only mentioning it for inclusion in the list.
What do you mean? Which court has determination?
And at that point of time, when your lordship was not there, Honorable Justice Kapoor had determination. So we had some urgency, we had mentioned
What is
there.
the urgency?
My lord,
Hurry up.
Urgency is this, my lord, asset was taken up by the receiver and in terms of an
No,
order.
you were not before the last week of September. Yes. Yes. Hurry up. Any other mentioning, Mr. Thakur? Yes.
My lord, by an order of 31st July, my lord, your lordship had by an order of 31st July, my lord had directed that the section 34 application would remain in abeyance till the pre-deposit was put in. My lord, this is an MSME matter. Now, my lord, the the decree holder has given me the computation of the amount. I am seeking leave to put it in the department, my lord. Without a formal order, I'm told the department will not accept the deposit. It could
Yes, to be mentioned tomorrow.
grateful.
My lord, I mean, I mentioned after matter, my lord, this is a section 34, my lord. I want to put in the 5,000 court fees, my lord. So I need a direction from the court, then only I can.
No, is it running in the list? What is it?
No, it is not writing in the list, my lord. Last heard on 17th June 2023, my lord.
Yes, third week of September.
Lordship, may I permitted to mention two section
obliged.
11 application Lordship of 2023. Lordship, the matter has due to inadvertence, the matter has filed in regular division, which should have been filed in commercial division. The matter appeared in the list on 3rd of August 2023, and there was a direction by Lordship that
I can't understand. Come back with facts. Yes.
May I have your lordship's leave, my lord, to mention GA9 in administrative suit number 2 of 2022, my lord. My lord, the application, my lord, is ready for hearing. The pleadings are complete. The matter was last heard on 3rd of July 2023, my lord.
My lord, I'm
praying
appearing
for
for the
inclusion.
defendants in this matter, my lord.
I'm
There
praying
are
for
other
inclusion.
applications also pending in this suit, my lord. May all those applications also be listed accordingly.
Yes, first week of October. Yes.
I'm grateful, my lord.
Can't hear you. Yes, any other mentioning?
My lord, may I have your lordship's kindly to mention, my lord, an application under section 29A. My lord, the mandate of the tribunal has expired, my lord, on 31st August 2023, my lord.
When did you file the application?
My lord, it has been filed, my lord, in the month of August, my lord. It was moved before the Honorable Justice Kapoor. My lord, an order has been passed, my lord, in that matter. My lord, the liberty has been given to mention before.
You don't know the dates. Come back with the dates. Yes.
May I
Yes.
have your lordship's kind leave for inclusion of an execution application, my lord. It was heard last on 8th October 2021, my lord. If it can be included in your
No,
list.
mention in the last week of September.
Yeah, my
Yes.
lord's kindly to mention.
Mr. Thakur, 1 minute. Any other first time mentioning? Yes, Mr. Thakur.
May I have your lordship's kindly to mention an execution application, my lord. Last heard on 23rd June. The award debtor, there was a
You have to mention a year, Mr. Thakur.
23rd June 2023. It was a part heard matter before a coordinate bench where there were objections taken to the enforceability of the award. It's a foreign award. Those were negated, my lord, and the judgment debtor was directed to file his affidavit of assets. He has not filed his affidavit of assets more than
But
8
if it's
weeks.
part heard before a
No,
court.
the part heard was released, my lord, by an order of 23rd June. Upon
Say that.
I'm sorry. Part heard was released by this order of 23rd June, my lords. The affidavit of assets has not been filed till date, my lord.
Yes, last week of September.
Grateful, my lord. Deeply obliged.
inclusion of the section 34 application of 2022.
You have to come back with the dates. Yes,
Madam,
yes.
This matter is EC 476 of
Can't hear you.
This matter is EC 476 of 2022. I am for the plaintiff. This matter last appeared on 17 July. After that, it is
Yes,
out
hand
of
up the
the
phone,
list.
please. Hand up the phone. Yes,
My humble prayer is for inclusion in the list.
come back with dates. Yes, appellate side.
On original side mentioning, Millet, this is an application for praying for extension of time for the learned sole arbitrator to publish the award. Millet, the arbitration proceedings have been completed, only the time to make and publish the award. Millet, this application for extension of such
What
time.
do you mean? Are you aware of section 29A of the Arbitration Act?
Millet, this.
Yes, come back with facts. Yes,
Your lordships mentioned this is not a contempt application passed by your lordships.
it's a original side matter.
No, appellate side.
Wait. Yes, appellate side matters.
But may I have your lordships kindly to mention one review application with the section 5. The order was passed by your lordship on 24th of January 2022, dismissing the writ petition.
Yes, not before the last week of September.
2
Last
weeks
week of
back,
September. No, last week of September.
Well, may I have
Yes.
your lordships mentioned this is a contempt application passed by your lordships. And a contempt application was
Contempt
hard on.
application was passed by the court.
Yes, yes.
Yes.
Well, no,
Come back, come back. You're
no, but
not even your sentences
no,
are
but
not in order.
7th July.
No, come back. Yes, yes.
If your lordships kind leave to mention my writ petition, my lord, this is a part heard matter before your lordships. Written notes of arguments have been exchanged by both parties.
Which
on-
part heard matter is this?
Manoj Kumar Bhagat. So his last,
Manoj Kumar Bhagat. Yes, yes. Manoj Bhagat ki part heard chilo?
yes, my lord, the notes were also exchanged.
Yes, 3rd week of September. Yes.
Grateful.
Contempt application. And then what?
Lordship urgency, my lord.
Yes, come back with facts. Call on the list.
Item number 1, Tata Motors Finance.
Milord, these 5 matters, Milord, there's an award, Milord, declaring, Milord, that the asset, Milord, can be, Milord, taken position, Milord, by the award holder and not dealt with, Milord, to recover the awarded amount. Milord, when execution was filed, Milord, they appeared, Milord, and Milord offered to surrender the asset. Milord, there's some difficulty. Your lordship was pleased to appoint a special officer, Milord, with his help, Milord. Now the assets, Milord, are with the petitioners, Milord. We have received the assets, Milord. Pursuant to, Milord, your lordship's order, Milord.
Yes, Mr. Dashgupta.
So
All 5 now with the.
all 5 now with the what award holder. Milord, what I was submitting, Milord, this can now will not be disposed of, Milord, to enable.
And what happens to the,
Milord, in terms
special
of the,
officer?
Milord, especially when we discharge, Milord, in terms of the award, Milord, we shall deal with.
and you have been paid? Paid?
Yes, my lord. First time I have paid, my lord.
What first time?
First order,
She-
my lord. You have.
This
given,
at
my
once,
lord.
Milord, we have paid the remuneration. Yes.
Very well. Any other work done after the first order by the special officer?
Milord, she has, Milord, she went and Milord has handed over the asset, Milord, taken position and hand over the asset to the petition.
Very well. According to the advocate on record of the award holder, in all the 5 execution cases, the 5 assets have been handed over by the award debtor to the award holder on
Milord, your lordship, the receiver's
Milord,
report
on
was on
11th
different
August.
dates. Milord.
11th August 2023.
on different dates, the last of which is on
11th August 2023.
11th August 2023. Stop. The it is accordingly prayed that the execution cases be disposed of on that basis. Stop. Next. The special officer's report, the learned special officer is present in court and the report is, have you handed up? And the report is handed up and hands up the report, capital R. Stop. Next, EC chart 5টা দিয়ে দেবে একসঙ্গে are accordingly disposed of in terms of the above. Stop. The special officer who was initially paid the remuneration directed will be paid an additional amount of rupees blank by the award holder. Stop. Anything else, Mr.
Milord, I'll be not entitled to not deal with the asset, not in terms of the award, not because the award says not I can.
What is the award?
No, the award says not that I can sell not and appropriate the sale proceeds.
Yes, the award holder will be at liberty, shall be at liberty of dealing with the asset in the manner as directed in the award dated
Milord, 22nd October 2019.
22nd October 2019.
I'm grateful, sir. Grateful.
shall be at liberty to deal with the assets.
Assets. Grateful, Your Lordship.
Item number 6, Hooghly River Bridges.
Yes.
My lord, we are ready with the section 56. my lord.
Where is the application, Mr. Mukherjee?
The application.
The restoration application.
My lord, it's come as to be mentioned. my lord.
No, but it's a, very well, yes. Yes.
Petition order.
Now, dismiss for default order টা কোথায়? Yes. একটা লাইন লেখো তো। The last কবে হয়েছিল order matter? This matter was called on 1st September 2023 when no one appeared for the petitioner. Stop. The court accordingly dictated an order dismissing the matter for default. Stop. Learned counsel appearing for the petitioner appeared subsequently and prayed for appropriate orders. Stop. The order was hence, the order, comma, as dictated in court, comma, was hence not signed. Stop. The matter appears today. Stop. Next. Yes.
My lord, this is my section 36 application. My lord, I have asked for an unconditional stay. My lord, alternatively, my lord, in terms as your lordship could deem fit and proper, my lord. The reason
Why unconditional?
my lord, I'm not coming within the scope of my lord 36 3, the second proviso where there is fraud. I have not pleaded fraud here. But still, my lord, the facts of the case are such that in exceptional circumstances, my lord, your lordship can possibly grant an unconditional stay. I'm relying on, my lord, two judgments, one of this honorable court as also one of Bombay High Court, my lord, where depending on the facts and circumstances of the case, unconditional stay can be granted. And my lord, I'm obviously also
Show me
relying.
the judgments first.
We made a compilation of all the judgments, my lord.
How many judgments?
My lord, on the proposition of unconditional stay, my lord, there are 3 judgments. And my lord, otherwise, my lord, in relation to my lord, on what terms your lordship will, if your lordship my lord,
No.
does not accept.
Individual judgments, please. Compilation only upon leave of the court. You cannot take it for granted that you will be allowed to file all the judgments. Individual judgments.
I will just let you.
Yes. Yes, Mr. Mukherjee, it's coming under the heading to be mentioned. Why do you want to argue the case now? Yes,
I'm ready, my lord. I'm absolutely.
you may be, but it's under to be mentioned. Yes, and it was only kept because you had appeared and apologized. Yes, list this matter. Tomorrow. Stop.
I will come with individual judgments.
Compilation only with the leave of the court, not otherwise. Next.
GTS India Private Limited.
I am for the petitioner, my lord. Lord, this is my application for revocation of a patent under section 64 of the Patents Act. Lord, this matter initially appeared before Justice my lord Mukherjee. My lord, due to personal reason, he has released this matter. Thereafter,
Yes, it's a Patents Act. It's what is
My
it?
lord.
It's a
my lord, for revocation of patent. my lord.
revocation of
My
patent.
lord, I am being late by Mr.
Yes, when should I fix the matter? It's of 2023.
Yes, ma'am. The patent was granted in June 2023. And may I indicate one thing that I would like to file I would not like to file an affidavit because
First, let me fix the matter, then all this. Yes, this matter has been assigned to this court. After a learned judge, after a coordinate bench was pleased to release the matter on 25th July 2023. Stop. Release this matter on 19th September 2023. Next.
SMS Pariavaran Limited, item number 8.
For the respondent, ma'am. Last order.
It was fixed on 11th September.
Please,
Right.
I know what you say. Yes, by an order dated 11th August 2023, this matter was fixed for judgment on 11th September 2023. Stop. However, since the court has finished writing the judgment and proposes to dispose of the matter along with another matter with an identical issue for consideration, lists this matter under the heading for judgment on 6th September 2023.
Great.
8 and 9 SMS Pariavaran, same.
Same order.
Great.
Item number 10, others trade link.
This is my application under section 11 for appointment of an arbitrator, my lord. But may I please file the affidavit of service?
Mr. Chaudhary is appearing anyway.
Yes.
Are you for all the, Mr. Mukherjee, are you for all the respondents?
Only one respondent, we are
respondent.
not representing that.
Yes.
May I also, with your lordship's leave, my lord, file a supplementary affidavit in this matter, my lord?
Served on
This
the other
is
side?
Served on the respondents.
Yes, Mr. Chaudhary? No.
I'm sure there's a miscommunication somewhere, my lord. May I have a copy, another copy, my lord? Sure, sir.
This is my application under section 11 for appointment of an arbitrator.
Yes,
But I am appearing for Others Trade Link Limited, my lord.
yes.
But I was being awarded a contract by West Bengal Power Development Corporation Limited, my lord. But there was
That's a respondent.
Lord, that's the respondent. Lord, an auction was conducted on 30th of September 2020. Lord, for lifting of dry fly ash from Bakreshwar Thermal Power Station, my lord.
Yes.
Lord, I participated and I became the highest bidder, my lord, and I was being awarded the contract, my lord. I'll just indicate the facts of this matter, my lord, before I take your lordships to certain documents. All the documents are on record.
No.
Lord, my bid was duly.
All the documents on record. Why do you need to file a supplementary?
But because post filing of this application, my lord, the contract was terminated, my lord. So I wanted to bring that particular, my lord, notice also on
Very
record.
well. Yes. Yes,
May I have your lordship's leave, my lord?
please continue. Yes.
My lord, my bid was accepted on 7th of, my lord, October 2020. Lord, I submitted the earnest money deposit as per the contract. My lord, the contract was initially for the period of 3 years. My lord, at this point of time, Lord, I was not being awarded with the final sales contract, which was there, my lord, stipulated under the e-auction notice and the terms and conditions.
Not awarded the final?
My lord, the sales contract.
So what were you awarded on?
My lord, I was
30th?
been given a letter of, my lord, acceptance. My lord, the contract was not, my lord, the contract was not handed over to me. My lord, thereafter, my lord, this was the period, my lord, during COVID-19, my lord. So my lord, there was some exchange of correspondence between the parties regarding the price of the dry fly ash, which was negotiated between the parties. I was awarded, my lord, the contract at rupees 316 per metric ton.
For lifting?
For lifting, my lord.
Yes.
Lord, thereafter there was some negotiations where I requested the respondent that please reduce the price. because this price is what has been offered is very
No,
high.
so 316 is not what you will get for lifting.
But this is what I have to pay.
You have to pay.
Yes. I'll have to
But
pay.
aren't you, no, I don't understand. You're rendering the service of lifting dry fly ash. Then why will you have to pay?
But I am actually taking the dry fly ash, for which I'll be lifting it for my own purpose, for my own commercial purpose,
Very
for
good.
which I have to pay 316
Yes.
per metric ton, which was agreed.
So you wanted reduction.
I wanted reduction, that was rejected. Ultimately, there was a show cause notice because I had to also deposit earnest money deposit. I had to pay up some upfront amount and a performance bank guarantee, which I could not pay. I was being given a show cause notice and my EMD amount was forfeited. But finally, after some,
You had to deposit EMD. So did you deposit?
I did not deposit.
How can it be forfeited then? If you did not deposit, how can it be
But I stand
forfeited?
corrected, my lord. The EMD was deposited. The bank guarantee was not furnished. Stand corrected, my lord.
Yes.
Lord, thereafter, after certain negotiations, my lord, finally I was awarded the contract on 21st of April 2021, which, my lord, is at page 72 of this particular, my lord, my petition.
Yes.
Lord, the contract was finally awarded at the sum which was initially I had to participate under the auction. So it was awarded at rupees 316, my lord. Subsequently, my lord, I had also, my lord,
That rate was not changed.
rate was not changed. My lord, I participated. My lord, the award was, my lord, duly granted. I thereafter, my lord, furnished bank guarantee. And my lord, at this, my lord, as per the terms of the contract, I lifted the materials. My lord, while this was subsisting, there was a fresh contract which was my lord, also issued. My lord, there was an expression of interest for the same area. There was a fresh contract which was also, my lord, awarded in my favor. While, my lord, I was executing my performance under the second contract, in the meantime, my lord, I received a notice from the respondent, my lord, stating that you could
So second contract was also awarded in your favor.
awarded in my favor. There was no, my lord, auction which was conducted. There was an expression of interest. I submitted my expression of interest and I was being awarded, my lord, with the second contract. While I was performing my duty and, my lord, under the second contract, my lord, the respondent issued a notice, my lord, stating that you have still not performed your obligation under the first contract, which was executed.
Yes.
And thereafter, the bank guarantee which you had submitted, we are invoking it. And, my lord, there was a notice of invocation. But immediately, my lord, I took recourse to, my lord, section 21. I invoked the arbitration clause and I, my lord, issued a section 21 notice on 15th of September 2022. My lord, the notice was received. My lord, no dispute, my lord, with respect to the existence of arbitration
So
agreement.
the 21 notice was in respect of the first or the second?
First contract, my lord. The dispute today, which I am presenting before your lordships, is with respect to the first contract, not the second contract.
Yes.
The dispute which I'm raising before your lordship is with respect to the first contract and the NIT. Because under the NIT, the first contract was issued and the NIT contained an arbitration clause, which I'll indicate to your lordship. Lord, I issued the section 21 notice. Immediately thereafter, I filed a section 9 before the commercial court at Rajarhat. That while the section 9 petition was being disposed of, not disposed of, there was an interim order passed in my favor, restraining the respondent from invoking the bank guarantee. This order
By the Rajarhat court.
by the Rajarhat court. This Rajarhat commercial court. While this
So
particular
you are apprehending what, a jurisdiction argument? No.
existence of arbitration clause, that's what I'm apprehending. When the order was communicated to the respondent, by then my bank guarantee was already invoked.
When the order was?
Communicated on the very same date, on the next date,
Yes.
same date,
You
it was
say next day, same day, what is the date?
15th of September 2022. We have communicated that there is an order against you, restraining you from invoking the bank guarantee. By then, the bank guarantee was already invoked.
Very well.
But ultimately, my lord,
So this is not a section 9, it's in 11.
but this is a section 11, my lord. Thereafter, my lord, the contract was also terminated. But while I was performing my second contract.
Yes.
But today I have suffered, my lord, I have suffered loss because of the unlawful invocation of the bank guarantee. And second, my lord, I have my EMD amount, which was also deposited and which under which I had also performed my obligation.
So why
That
do you
was also
say-
forfeited.
If that is such a strong case, why do you think that the respondents will say that there is no dispute? Yes, Mr. Bagh.
Yes. You're right. Very humbly tender my unconditional apologies, my lord,
That's all
for
right,
not being
yes.
here. My lord, I'll only show two documents, my lord. The arbitration clause is not in dispute. That is at page 35. This is the clause contained in the my lord, notice inviting tender. My lord, this is an arbitration clause at page 35. And the bank guarantee, which is an issue, my lord, because the bank guarantee has been invoked. That is, my lord, our damages which we'll seek, my lord, in the claim in the arbitration proceeding. My lord, kindly take up page 79 once. That's the copy of the bank guarantee security deposit. You know, there is an admitted dispute. There's a dispute between the parties, and that is an admitted position. I'm not troubling a lot.
What is, that's the bank guarantee?
Page 79 is the bank guarantee, my lord.
Yes.
Kindly see, my lord, at the top left-hand corner, bank guarantee number is given and the date is given, 27th April. The first line, my lord, in accordance with your auction dated 30th September 2020, being the H1 bidder. That is the reference, my lord, to the NIT. The NIT is at page 18. The NIT, my lord, is dated 13th September 2020. That is the NIT, my lord, through which the e-auction has happened on the same day, 30th of September 2020. The bank guarantee was given under the NIT.
Yes.
Because what I am apprehending the submission which will come, my lord, is this, that there is an NIT, there are two work orders. First work order does not contain an arbitration clause. Your dispute is under the first work order. Perhaps this is what, my lord, will be submitted.
So arbitration clause is in the NIT?
In the NIT. That's page 35.
And
my
the
lord, may I indicate-
NIT is the source of both the work orders?
Yes, my lord. It is the source of both the work orders. Also, my lord, I have a better case because my bank guarantee is an issue. I had filed a section 9 apprehending, they'll invoke the bank guarantee. That's exactly what happened when we had an order in our favor. But before we could communicate it, my lord, in the morning, they had already invoked
So
it.
that's all right. And what is the claim now?
And the claim now is, my lord, the bank guarantee of 37,92,000, my lord, which has been invoked according to us illegally, illegal termination of the contract, and, my lord, the earnest money deposit of 15 lakhs, which we had given in the terms of the, my lord, NIT.
So 37 plus 15 plus?
The 37 plus 15, and then, my lord, the damages which we'll seek, my lord, both specified and
How much?
damages. Huh? My lord, 52 lakhs admitted, that's a quantified, my lord, and the damages, my lord, we are yet to, because, my lord, that will depend on the unspecified damages.
Very well. And your 21 notice says what?
21 notice is at page 116, my lord, it's dated 15th September. My lord, here we have indicated in the first paragraph 15 lakhs, that's, my lord, the earnest money deposit. Paragraph 6 is, my lord, the bank guarantee which we had given the advance.
And this relates to the first contract?
It relates to the, my lord, NIT and the first contract.
NIT and the first.
NIT and the first contract.
So
My lord,
second contract is not of any relevance?
No, my lord, it is not. It is not. In fact, my lord, the main dispute is with regard to the invocation, wrongful invocation of bank guarantee, and, my lord, bank guarantee at page 79 relates back to the NIT. So it is not a case, my lord, that.
And show me the arbitration clause, please.
My lord, the arbitration clause, your lordship will kindly take up page 35. The NIT starts from page 18. Page 35 is the arbitration clause, clause 19 at the last, my lord. The last line of the page, page 35, and the over the page, my lord, disputes and differences arising out of or relating to this agreement shall. So it's not a pathological clause, shall be resolved through amicable mutual discussion.
Not a what clause?
Not a pathological clause. But if the
What is a
arbitration
pathological clause?
The pathological clause if the arbitration clause is not in terms with section 7, then, my lord, it's a defunct clause and it becomes a pathological clause.
Pathological? How?
It's called pathological, my lord. Pathological means, my lord, in my very respectful submission, it means a clause which is not workable. So, my lord, if there is a clause, if there is a word which is used as may, the parties may refer this to arbitration, it becomes pathological. But Jagdish Chandra, it says that if it is may, the party's intention is not, my lord, crystallized.
So
hence
if
they
it's
cannot
may,
appoint.
then it's pathological.
So if it is interpreted that they had only contemplated that arbitration is one of the routes through which, my lord, the disputes will be settled, then they did not, my lord, agree to
Are
the
you
only route
using
being
the word from a judgment?
You know, that is in several judgments. Yes, my lord.
Says
my lord,
pathological?
pathological. That's the term, my lord, used for a defunct arbitration clause. Pathological arbitration clause.
Delhi High Court or Bombay High Court?
This is, my lord, Chartered Institute of Arbitrators, London. my lord, since I'm a fellow of the institute, my lord, we had, my lord, had the occasion to read this as to how to interpret a pathological arbitration clause.
No, but any meaning given as to why the
Yes, my
word
lord,
pathological is
pathological,
being
they use the term pathological if it is a non-functional, non-workable arbitration clause. It's then that they may not use the term pathological arbitration.
very good.
That's but here, my lord, this is the arbitration clause, and it is the venue is Kolkata, governing law, my lord, and the clause 20 is the governing law, 21 is the legal jurisdiction.
Very well. Yes, Mr. Chaudhary. That is all, Mr. Bag?
Lord, yes.
Lord,
But in case my learned friend, my lord, argues
Naturally,
non-existence of,
it's your
then, my lord,
petition,
those
so you
three-
will have the last
three
word.
judgments, my lord, of my lord,
Yes,
incorporation
yes.
by reference.
Yes, Mr.
I
Chaudhary.
rest my case.
Lord, I will, my lord, rely on their invocation notice under, my lord, which is at page 116. Lord, the petitioner cannot improve his case, my lord.
That's a 21 notice.
Yes, my lord. Page
Yes.
116.
Yes.
Lord, sequence of events is contract number 1, which emanates from a tender process. And then, my lord, that's not fully worked out. And then there's contract number 2. This is not the sequence which he makes out. Very important, my lord. Now, please see, my lord, page 116 at paragraph 11, page 118. Arbitration clause, my lord, which is invoked before your lordship is in contract number 1. My lord, kindly see, my lord, paragraph 11 first.
Yes.
It is a settled law that you cannot sell the same item at 2 different prices under the garb of 2 different tenders floated in different periods. Once the new tender has come into effect and sale contract which has been issued pursuant to the previous tender automatically stands terminated and merges with the new one. Hence, you had no right to encash the bank guarantee dated such and such since the contract dated 21st April
1 minute.
2020.
Mr. Mitra, what are you doing? Advising both sides. What are you doing?
I'm only finding out how long it will take. And so I'm telling them, please inform me in time so I can come back.
Very well.
But
Yes.
this is a nice word I learned, pathological arbitration clause. I learned something from one of my juniors.
Yes. Yes.
I should have used it yesterday. That hence you had no right to encash the bank guarantee dated April 27, 2021, since the contract dated such and such itself stood terminated and is no longer in existence. So that's not a case of novation of the first contract by the second contract. Consistent with this stand is paragraph 9. Last 3 lines. Accordingly, by action of the parties, the first tender and its sale contract had automatically ended. So, my lord, if there is novation of the first contract by the second contract and the admitted case of novation in the section 21 notice, and my lord, the arbitration clause is in the first contract, because of the novation it perishes. So there's nothing, my lord, on the basis of which it's obliterated. So there's nothing on the basis of which a reference can be made. Now this was, my lord.
Second contract doesn't have an arbitration
No, my lord.
clause.
They are, my lord, relying on the, that's a different one, but not invoked. The one invoked is in the first contract. So, my lord, once you say that I'm invoking the arbitration clause in the first contract and you yourself say that there's been a novation, in that case, my lord, there's nothing, my lord, which can be referred to arbit. There's no arbitration agreement. Now, my lord, 2 disclaimers, my lord.
Yes.
Firstly, there is a Supreme Court judgment which says that, I should point this out, that novation is a question when, my lord,
Which has to be decided by the
decided
arbitrator.
by the arbitrator.
Yes.
But that, my lord, I would read akin to a limitation issue, as in notel, where it is explicitly clear.
Yes, yes. Notel says doubt arbitrator.
Doubt arbitrator.
Clear court.
Same thing about novation.
Yes.
If it's an admitted by the petitioner himself that there is a novation, it need not, my lord, travel to the arbitrator. Second, here admission is in the section 21 notice and, my lord, in the section 9 application. If your lordship, I have 2 judgments, my lord, which I want to
No,
rely
section
upon.
9 application how? By the order?
No, my lord, by the petition. the case made out in the section 9 application filed before the Rajarhat.
Says what?
Lord, I have a.
No, just tell me.
Lord, I have a copy of the application. The copy section 9.
It's your case, Mr.
Yes, yeah.
Chaudhary. You have to show it.
Yes, I have unfortunately not one copy of the section.
Just
9.
tell me, just read out
Yes,
the
Lord, I'll read
paragraph.
out.
That's all.
The petitioner states that with the issuance of the said expression of interest being accepted by the respondent, the auction catalogue dated 30th September 2022 stood automatically determined and merged with the present expression of interest upon the sale contract dated 8th April 2022 being issued. So we not again merged, determined and or merged with the present expression of interest upon the sale contract. Now, this is page 9, paragraph 20.
Yes. Anything else, Mr. Chaudhary?
Not the two judgments.
On what point? Arbitrator will, that's a disclaimer point.
Yes, Lord.
That the arbitrator will decide the issue of novation. That's a disclaimer point.
No, this is Milord, that if there is novation, the arbitration agreement perishes. Milord, the parent judgment, Milord, is Kishori Lal, Union of India versus Kishori Lal.
That's on the section 62.
Yes. Lord, may I please, Milord, refer to paragraph 10 of this judgment. Now, this is reported at AIR 1959 Supreme Court 1362. I'll give you a copy. Lord, paragraph 10. This follows, my lord, the judgment, my lord, in the case of Heyman versus Darwin of the English courts.
Yes.
Lord, may I read paragraph 10? The following.
It's Heyman's.
Heyman's.
Yes.
The following principles relevant to the present case emerge from the aforesaid discussion. An arbitration clause is a collateral term of a contract as distinguished from its substantive terms, but nonetheless, it is an integral part of it. However comprehensive the terms of an arbitration clause may be, the existence of the contract, no, this is important, the existence of the contract is a necessary condition for its operation. It perishes with the contract. 3. The contract may be non-est in the sense that it never came legally into existence or it was void ab initio. 4. Though the contract was validly executed, the parties may put an end to it as if it had never existed and substitute a new contract for it, solely governing their rights and liabilities thereunder. 5. In the former case, if the original contract has no legal existence, the arbitration clause also cannot operate, for along with the original contract, it is also void. In the latter case, as the original contract is extinguished by the substituted one, the arbitration clause of the original contract perishes with it. Between the two falls many categories of disputes in connection with a contract.
So which of the 6 clauses?
4, my lord.
4.
4, my lord. Though the contract was validly executed, the parties may put an end to it as if it had never existed and substitute a new contract for it, solely governing their rights and liabilities thereunder. Now, my lord, in 5, the second line, third line of 5, from the middle of the sentence, middle of the line, in the latter case, as the original contract is extinguished by the substituted one, the arbitration clause of the original contract perishes with it. So, my lord, in a case of novation, the arbitration agreement perishes. Now, this is, my lord, relied upon in, my lord, 2003, volume, 13, volume 10 SCC, 535.
Mr. Chaudhary, novation, at least section 62, is a matter of both parties being ad idem on the issue of novation and agreeing to novate and substitute the contract with a new one. Here you are relying on one paragraph made in their section 21. saying that it is their case and whatever application, section 9 application, it is their case that the first contract merged into the second. That
But
is
I am on a,
62.
Milord, I am on a, this is
Or
again,
Heyman's versus Darwin, that was also, that it was clear. Both parties were on the same page, as it were.
yes. Now, Milord, I am on a principle, like in a order 7 rule 11 application. If, Milord, a petitioner in a section 11 application carries a case to court that I have issued a section 21 notice where it is my case that the first agreement has stood novated, and I follow it up with a section 9 where it is my case that the first agreement has stood novated, then, Milord, I may stop from proceeding or making out a contrary case. Milord, I am, Milord, not even asking for filing of affidavits, because I am, Milord, humbly submitting.
So the petitioner wants which contract to be referred to arbitration?
The first contract. The first contract. Milord, kindly now, Milord, come back to
yes.
the section 21 notice at page 116. Milord, he has to, Milord, base his case on his section 21 notice. Now kindly see, on the basis of this notice itself, he couldn't have come to court. Milord, please see from page 116. First paragraph is, you had issued a notice inviting tender for online auction for the disposal of dry fly ash lying at such and such, where our client had participated. 2. Our client, being a successful bidder, was awarded the tender for lifting such and such metric ton. But in spite of repeated requests, the sale
Mr. Chaudhary, that's clear. In any case, if the second contract doesn't have an arbitration clause, then the petitioner can't.
No, that's not the invoke clause.
Yes.
That's not the invoke clause. So, Milord, sale contract was not awarded. 3. Surprisingly, despite having failed to issue the sale contract by a letter dated 18 January 21, you had fraudulently and illegally, without any basis, had threatened our client by issuing show cause notice. We, by our letter, had intimated such and such. Paragraph 5. Please note that no sale contract was ever issued. 6. Pursuant to the sale contract, our client had provided security deposit in the form of bank guarantee. Now, this is very important. So, our first contract results in issuance of a bank guarantee by them. It is also to be noted that in spite of issuance of such sale contract and in spite of several requests, the said earnest money deposit was never refunded to our client.
Mr. Chaudhary, I've read it. Yes, anything else?
No, Madam. Then paragraphs 9 to 11 make it clear that their cases, 9 to 12, their cases that the first contract is novated by the second.
That's all?
That's
Lord, may I quickly answer some factual?
I'm telling you what you will have to answer. Number 1, novation.
Lordship.
All right.
Fine.
Number 2, what remains, it's actually 1 and 2 are the same. What remains of the first contract, if your case made out in the 21 is that the first contract has merged into the second. All right. And number 3 is, if you have, what you have actually gone in for in the commercial court at Rajarhat. That's all.
Very grateful. Milord, it's not a case that there are two contracts. It's a case, Milord, there is a notice inviting tender, and therefrom, Milord, there are two contracts. It has been submitted that the first contract has been novated and the second contract does not have an arbitration clause. That's not factually correct, Milord. Second contract has an arbitration clause. First contract.
Correct, my learned friend. My answer was that the first contract arbitration clause has been invoked. The other arbitration clause is irrelevant.
Yes.
But first contract does not have an arbitration clause. My first submission. It
does not have an
It
arbitration
does not have an
clause.
arbitration.
The NIT has it.
The NIT has it. Milord, the NIT is from page 18 onwards, and Milord, the arbitration clause is at page 35. That's a part of the NIT.
Yes.
The first work order, which is the first contract, starts from page 72. It's dated 21st of April 2021.
Yes.
That starts from page 72. It does not have an arbitration clause. Page 81 onwards is not the second contract, which is 8 April 2022, which has an arbitration clause. So even if, Milord, may I request your lordship to take up the section 21 notice. Only 3 paragraphs I'll refer, Milord. Paragraph 6, which is at page 117. paragraph 6, my lord, at page 117.
Yes.
Pursuant to the sale contract dated 21st April 2021. But this is in reference to the first contract after the NIT, my lord. Issued in favor of our client provided a security deposit in form of bank guarantee. The number is given dated 27th April 21, issued by HDFC. This is the amount, 37,92,000. My lord, thereafter, this is the amount of bank guarantee. I've shown from the document itself, the bank guarantee, that the reference is to the NIT, the 30th September 2020. That's the NIT date, my lord, and the e-auction. Now, my lord, paragraph 9, my lord, subsequently another expression of interest was uploaded. Several bidders were this is in reference to the agreement dated 8th of April 2022 at the middle of that paragraph. 8th of April 2022. The first tender and its sale contract had automatically ended. There is no question of continuance of bank guarantee. HDFC. Now kindly see, my lord, this is in reference to April 8, 2022. This agreement starts from page 81. There is an arbitration clause here at page 83. My lord, we are not invoking this clause. My lord, one more document may, my lord, only indicate. My lord, paragraph 10, the next page. Paragraph 10, only the last two lines, it says, my lord,
Enough, I've made up my mind. Yes. This is an application under section 11 of the 1996 Act for appointment of an arbitrator. Stop. The agreement binding the parties before the court is a notice inviting tender of 30th September 2020, which was for engaging the petitioner, which was for engaging an entity for lifting dry fly ash. Stop. The petitioner was, the undisputed facts before the court are that the petitioner was accepted, that the petitioner's bid was accepted, and the letter of acceptance was issued to by the respondent to the petitioner on 30th September 2020. Stop. The petitioner was, however, subsequently handed up the contract on 21st April 2021. Stop. The negotiations between the parties with regard to the price of lifting did not come to any fruitful avail, did not lead to any fruitful result for the petitioner, who sought for reduction of the price and ultimately culminated in the contract of 21st April 2021. Stop. The petitioner furnished a performance bank guarantee and an earnest money deposit in pursuance of this contract. Stop. The petitioner was thereafter awarded a second contract, which the petitioner also started to perform. Stop. However, disputes arose between the parties in relation to the first contract, which was awarded on what is the date of the second contract?
8 April 2022.
Second contract যেখানে বললাম ওটা হবে 8th April 2022. Stop. তারপরে কি বললাম? Yes. First contract of 21st April 2021, and the respondent invoked the performance bank guarantee in relation to the first contract and forfeited the petitioner's EMD. Also, EMD also in relation to the first contract. Stop. The petitioner invoked the arbitration clause by a notice dated 15th September 2022 with regard to the first contract, and also filed an application for interim relief before the commercial court at Rajarhat. Stop. The petitioner obtained a restraint order on the respondent on 15 September 2022, but found out later that the respondent had already invoked the performance bank guarantee. Stop. Next. The disputes, the alleged dispute brought to the court admittedly relates to the first contract. The NIT dated 30th September 2020 and the first contract of 21st April 2021. Stop. Next. Learned counsel appearing for the respondent opposes appointment of an arbitrator by urging that there is no dispute before the court for which an arbitrator can be appointed. Stop. The basis for arguing this is that according to the petitioner's own case made out in the notice issued under Section 21 of the Act on 15 September 2022, the petitioner has stated that the first contract merged into the second contract. Stop. Counsel also places a paragraph from the Section 9 application, which was filed by the petitioner for interim relief, to with regard to the same point, namely that the petitioner's own case is of the first contract not being in existence anymore. Stop. Counsel submits that this is a case of novation where the first contract has merged into the second contract along with the arbitration clause. Stop. According to counsel, there is hence no subsisting arbitration agreement between the parties. Stop. Next. The only question before the court is whether there is a dispute between the parties for which an arbitrator must be appointed. Stop. The objection taken on behalf of the respondent must also be decided. Stop. The issue, in essence, is whether the first contract has perished, carrying with it the arbitration clause, and subsequently leaving the parties, subsequently leaving the court without any arbitration clause to look at for the purpose of the present application. Stop. Next. The invocation notice of 15 September 2022 contains a statement contains a statement by the petitioner that the previous tender automatically stands terminated upon the new tender coming into effect, and leading to termination of the previous tender contains a statement to the effect that the previous tender has terminated and merged into the new tender. Stop. The question is whether the court can come to a finding of novation under section 62 of the Indian Contract Act, 1872, on the basis of this statement alone. Stop. Next, section 62 at a Contract Act, Contract Act.
One interruption, if your lordship
Yes.
permits. Just 2 lines below the merges with the new one is the phrase is no longer.
I will hold that there is no dispute. You still want to go on with the interruption?
No. No, just
What is interruption?
is no longer in existence. 2 lines below that.
Very well. যেটা বললাম ওই যেখানে বললাম stands terminated and merged, ওখানে আরেকটা দিয়ে দাও, and that the earlier contract is no longer in existence. Stop. তারপরে প্যারাগ্রাফটা কি বললাম? Stop. Section 62 comes into effect where parties to a contract agree to substitute a new contract or to rescind or alter the earlier contract, pursuant to which the earlier/original contract need not be performed. Stop. The section involves the parties to a contract being ad idem on the point of the earlier contract being novated or rescinded, and thereby agreeing to substitute the earlier contract with a new one. Stop. In the present case, this is the unilateral statement made by the petitioner is in any event arguable on the facts of the case. Stop. There is also no evidence that the respondent agreed to the petitioner's stand by way of a reply. Stop. Admittedly, the respondent did not reply to the notice invoking, to the petitioner's notice invoking the arbitration clause. Stop. Next. The related issue is whether the first contract perished, carrying with it the arbitration clause. Stop. This argument is also fallacious, since the arbitration clause is contained not in the first contract specifically, but in the NIT of 30th September 2020. Stop. The NIT is really the source document from which the petitioner, from which the respondent awarded the two contracts to the petitioner. Stop. Hence, comma, there is no question of the arbitration clause in the NIT having perished or being substituted by a new contract. Stop. Union of India versus Kichorilal Gupta, AIR 1959, SC 1362, laid down 6 circumstances, 6 principles for in relation to extinction of the arbitration clause and based the same on the continuing existence of the arbitration clause. Stop. This decision would have been relevant had the respondent been able to show, BEEN, been able to show that the arbitration clause in the NIT perished by reason of the parties to the NIT agreeing to substitute the NIT, the arbitration agreement, with a fresh arbitration agreement. Stop. This is not the case made out by the respondent. Stop. Next, the objection having been taken care of, comma, the merits of the factual conspectus in the matter points inescapably to a continuing dispute between the parties. Stop. The respondent has invoked the performance bank guarantee furnished by the petitioner and forfeited the EMD. Stop. The respondent invoked the bank guarantee in the teeth of the order passed by the commercial court at Rajarhat. Stop. These facts would certainly point to a dispute between the parties and one which needs to be resolved by an arbitrator. Stop. Next, AP 865 of 2022 is accordingly allowed and disposed of by appointing blank to act as the learned arbitrator, as the arbitrator, subject to the learned arbitrator communicating his/her consent in the prescribed format to the registrar original side of this court within 3 weeks from date. Stop. The petitioner's advocate on record shall communicate this order on the arbitrator by 7th September 2023, along with the requisite details of the contact person of the petition.
One indulgence, Milan. That I would be permitted to take this point because there's no.
Yes, yes, of course.
Kindly mention that.
Yes,
Otherwise,
yes.
I'll be precluded.
Yes. Needless to mention, comma, the objection, the respondent will be at liberty to take the objections before the take the objections which were urged before the court, which were urged in the present application in the arbitration. Stop.
Grateful.
Rescind. 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 Yes, next.
Section 11.
Item number 11, Mr. SAS India.
My lord, I'm for the petition. May I file the affidavit of service? My lord, this is a section 11 application. The petitioner was appointed as.
You have to show, have you served them?
Yes,
When?
my lord,
Both applications.
given the affidavit of service, my. At page 9, my lord, it says that on 10th August, item was delivered to address, my lord. The page 10.
Very well. You communicate this order on them and come back.
All right. Yes.
Dover Terrace, how much time will you take?
And my lord, I can send today, then within 3-4 days, they should receive.
Yes, the appellative service shows that the respondent was served on 10th August 2023. Stop. No one appears for the respondent. Stop. List this matter. On 11th September 2023. Stop. The petitioner shall communicate this order on the respondent.
Gratefulness.
Next.
Item number 12, Koilas Traders.
May it please your lordship. Lordship, this is my application under section 11 of the Arbitration and Conciliation Act.
Yes.
Not on the last occasion, I had sought time as I had not been able to affirm my affidavit of service. My learned senior friends are appearing.
for the.
Yes.
So, my lord, this agreement was entered into.
Microphone, please.
My lord, this agreement, namely a contract agreement, was entered into by.
I can't hear you. Adjust the microphone.
My lord, this
Yes.
agreement, namely a contract agreement, was entered
What is
into.
the contract agreement?
Termed as a contract agreement, my lord, appearing at page number 14, was entered into by and between the parties herein for distribution of Ayurvedic goods, my lord.
Yes.
The petitioner before your lordship was a stockist and distributor of goods in southern regions of India. My lord, you will kindly turn to page 19 of the.
No, what is the
application.
scope? Distribution of goods means any goods.
Ayurvedic goods, my lord.
Yes, so how is the respondent involved?
My lord, the respondent Dhanvantri Biosciences was the producer of such Ayurvedic goods. my
Say
lord.
that.
Was the producer of such Ayurvedic goods, my lord. My lord will kindly come to the agreement once at page 14.
Yes.
At page 19 of the arbitration.
Sir, what
clause.
is the date of the agreement?
It's in August 2021. My lord. It is an undated, no specific date to the agreement.
How do you know it's August then?
My lord, post entering into this agreement in August, goods were supplied to the petitioner in Kerala to stock and to distribute to the distributor.
No, how do you know it's 2021?
Post-August, in August 2021, pursuant to this agreement, I had paid the security deposit that is enumerated in this agreement, and goods from the respondent were given to me to stock and distribute to the respondent distributors. My lord, the scope of this agreement is that goods were to be received of the respondent by me and stored by me. The goods so received by me were to be given to the distributors of the respondent, who would then sell in the local markets.
Yes, which page did you want to show?
My lord, I wanted to show page 19, my lord.
19.
Yes, my lord. My lord, clause 12.
Yes.
I must indicate, my lord, before the arbitration procedure was mentioned herein, there is also a clause for mediation wherein the parties would attempt to amicably settle the disputes. My lord, by a letter dated,
So you
13
were
December.
showing page 19, so
Yes, my
complete
lord. In
that.
page 19 itself, my lord.
Yes.
There is a process for mediation of disputes, if any, arise between the parties.
Point to the place.
Kindly, my lord, kindly sees any party fails to or refuses to or agree to participate in the ADR procedure, or then the party shall be free
Where
to
are you
litigate.
reading from?
My lord, clause number 12.
Yes, list this matter tomorrow for counsel to get ready, for learned counsel with the petitioner to get ready. Next.
Maybe on Thursday. I'm having a personal difficulty for a week now.
Thursday.
But I need 2-3 days to
I do
some
not-
medical urgency in my.
None of you have a clue.
But I am clear with my.
You don't even know that Thursday is a holiday.
Thursday, I missed out. I have some. So any other day, from maybe in the next week, I would.
No,
be grateful.
day after tomorrow. Yes, list this matter on 6th September 2023. Stop. Next.
I apologize.
Grateful.
Nomita Bhattacharya.
I am appearing, my lord, for the petitioner, my lord.
This is a section 11 application arising out of a development agreement. Arbitration clause is contained in the development agreement.
Mr. Sen, don't hit the ground running. Let me have the papers first, please.
I want to file an affidavit. That's my preliminary submission.
My learned friend is appearing for developer.
For the respondent number 1.
Your Lordship, I'm sorry, my lord, the supplementary affidavit contains the development agreement with
Who is
the
the developer? How will I understand, Mr. Mitra? The
I'm for
first
the-
one.
No, I'm for the respondent number 1. That's what
And
I
who
tell you,
is,
Lordship, my lord.
who is two?
But the dispute is like this, my lord.
No, what is your connection with the first?
That is what I am explaining, my lord. The parties. But
I
the
am the executor
development
of the will.
agreement,
1 minute. Yes, Mr. Mukhopadhyay.
My lord, the dispute, my lord, relates to, my lord, a development agreement executed by my father, my lord, who had left behind a will. I am the executor under the will, and I am also his son, my lord. The
Very
other
and I am
legal
the
heirs.
other intestate heirs of the of the deceased who entered into the development agreement with the developer. So, my lord, the development agreement, I have said that it is absolutely unconscionable, and not only unconscionable, my father was coerced into executing the.
So you are the son of who? You
I am
and
the,
Mr.
I am
Mukhopadhyay?
the widow, daughter, and son of the person who executed the development.
So your husband and father?
Yes, husband and father. Husband
And
father.
you're the brother of the respondent number 2?
Right, my lord. Now, my
Yes.
lord, I just tell your lordship,
Yes.
this development agreement, when I found out about this development agreement, 1,93,000 square feet total area at Rajarhat, 20,000 is the allocation allegedly of my father. But if I have the father left behind a will, the will is under challenge.
Then why have you made Mr. Mukhopadhyay a party?
Because he is the executor and he is supporting the developer. Both of them have instituted a friendly arbitration where one is supporting the other. They have gone to the division bench in a section.
Friendly as opposed to pathological.
No, not pathological, my lord.
Yes.
It is a very active arbitration agreement. And with active participation, they want that this unconscionable allocation to be given effect to as fast as possible. So, and for that purpose, not only, my lord, they instituted a section 9. From a section 9, they came up in division bench before this court. And there, my lord, this collusion is apparent where they agreed to the allocation. What
But
you
then
will-
how will Mr. Mukhopadhyay benefit from this?
Yes, that's the point. Mr. Mukhopadhyay will not benefit. The estate will not benefit. Maybe Mr. Mukhopadhyay will benefit personally, but the estate will not benefit.
But you are brothers.
But that's the unfortunate part of it, that the mother and the sister and the brother has to go against the other person. So, my lord, when this unconscionable alliance was brought to light on the basis of the recording in the order that my brother has sided with the, not only sided with the developer, agreed in a section 9 proceeding that let there be this much, let there be the allocation between us.
Yes.
So there, my lord, I wanted to intervene. My intervention was not allowed because I have other remedies. I went to the Honorable Supreme Court. And there the Supreme Court
intervened in the arbitration.
In the section 9 appeal. And my lord, my intervention was not allowed because I have other remedies. And my lord, I went to the Honorable Supreme Court against that order. There the Supreme Court clearly specified that as the heir of the person who has entered into the development agreement, I will be entitled to have all my remedies in law, including approaching the arbitrator appointed at the instance of the developer. What the developer and the other side had done, in the meantime, on a section 11 application, they have got an arbitrator appointed. Very well, my lord. So when this Supreme Court order came, I naturally applied to that arbitration proceeding that in terms of this, I am a legal heir, but my interests are in conflict with the interests of the executor. So I have a separate claim arising out of this agreement. I should be allowed to participate in this arbitration proceeding. That application filed in January 2023 could not be heard out till now. The arbitration proceedings at the instance of the developer commenced in September 2022. No pleadings have been filed.
Mr. Sen, you are here in a section 11.
Yes.
I'm not on the procedure.
No, I'm not on, I'm saying that. Why? Because this question will arise if I have already approached an arbitrator, how my section 11 lies. This can be the question. So here I say.
So what is wrong with the arbitrator?
But what is wrong with the arbitrator in the sense that my intervention has remained pending from January 2023.
So you want termination and appointment? What is it that you want?
But what I said that there was no necessity for me to come to a fresh reference if the reference which is already initiated at the instance of the developer against the executor, there I can be added as an independent party. As
No. So Mr. Sen, is it correct that that reference has proceeded good, bad, indifferent with regard to the speed, but something has happened in that reference?
Nothing has happened except my section 16 application, intervention application, whatever I may call it, has been filed and it was being argued. But in the meantime, they themselves have come up with an application before the same arbitrator, Mr. Mukhopadhyay's client. Sorry, Mr. Mukhopadhyay's client has come up with an application that the arbitrator's mandate has terminated because there is no statement of claim and 6 months have lapsed. So that proceeding is under a limbo.
So now it's become what, an unfriendly arbitration?
I won't say it is an unfriendly arbitration because according to me, they have no dispute interest there.
But Mr. Sen, it's the point of law. It's a point of law.
Yes.
If already there is a reference, you have filed your section 16, whatever be the pace of the reference, can you come to the court on a section 11?
No, that is my case.
First, it has to be a termination or termination, substitution, whatever. That should be the course.
Your Lordship will kindly consider this. If your Lordship sees under section 40 of the Arbitration Act,
yes,
the arbitration agreement is not discharged upon death of any party.
Yes, yes.
And it continues against the
40 subsection 3.
Sub-
No. 41 and 2 is what you're saying.
Yes.
Subsection 3 goes slightly different.
Nothing in this section shall affect the operation of any law by virtue of which any right of action is extinguished by the death of person. If it does not survive.
Yes.
That point, my lord. But the question today is, my lord, so therefore, I have an independent right in respect of the development agreement and the arbitration clause contained there.
Mr. Sen, I'm aware of 40.
Yes.
All right. 40 read with 35 and all those, I think there's one decision of the Supreme Court. But the point is that whether section 40 allows you to come to a court asking for an appointment of arbitrator where there is already a pending reference.
The pending reference is not at my instance.
No, Mr. Sen, that is a matter of fact. Come on the law, please, first.
Yes.
Because I have taken a view that even in a case of a 14 and a 15, parties will not go back to 11, but under 15 too, same rules will apply.
Yes.
So therefore, it will be you will have to go from that, you will have to proceed from that stage. So if that is the view taken, and there's a Supreme Court which is slightly different, but I don't think the law permits you to come to a court with a fresh section 11 appointment, subject to what you say. You may convince me, and I may change my mind.
But here, my lord, your lordship will have to consider what is the arbitration about. The pending arbitration. Pending arbitration has been initiated by a developer.
Is it the same subject matter or not?
Well, it is in respect of the same development agreement.
But no, you have participated in the arbitration.
I have not, but
you have told me that you told me that you filed a section 16 and that's been
I am still outside the arbitration. Kindly see what is happening. I am not being allowed to have an entry in the arbitration.
Come on the law first.
Yes, my lord, that is the point, my lord, which I want to take, my lord. If your lordship kindly sees, first, my lord, your lordship will see the development agreement, the arbitration clause. it is, my lord, in the supplementary.
No, no, no. Come on the section, the 1996 Act first.
Yes. On the 1996 Act, if your lordship sees, section 21 first.
Yes.
Lordship has found section.
Yes.
21. Unless otherwise agreed by the parties, arbitral proceedings in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. Here, apparently, section 21 notice was
Not served on you. Was served on you or not?
No.
Yes.
Section 21 notice was served by the developer upon the executor. Whatever, naturally, unnaturally, we don't know, but it is served upon the developer. Based on that, there was a section 9 proceeding. So they had a dispute which they want to refer to arbitration. Based on that, a section 9 proceeding was initiated again by the developer in pursuance of the section 21 against the executor. Then some sort of an interim order was passed. There was a proceeding before under section 37 from that proceeding. So section 9 continued up to High Court.
No, who filed? The executor filed the 37.
Yes.
Yes.
I'm sorry, my lord, the executor filed a 9 and the developer filed a
How can be a
37.
9, 17 or a 9?
9 before the court, because their stage was only 21 at that point of time.
Yes. So pre-reference.
Pre-reference.
Yes.
So all arising out of the 21 notice initiated by the developer. His particular case in the 21 notice relating to some non-performance of the development agreement. And he wanted specific performance of that, impliedly. So that came up to the division bench. Before the division bench, there was some sort of an agreement between the executor and the developer relating to the allocation of the original owner. What would be the allocation of the original owner?
Mr. Sen, not so much in detail. Just
Very
tell
well.
me that how does 21 help you?
Now kindly see, now only.
If I can use an affidavit, because all these are not on record.
No, everything is on record.
What is not on record, Mr. Mitra?
Well, there's section 16 application. Then
But these are not relevant for having an arbitrator
and
appointed.
the minutes of the arbitration, because they are appearing, they
Now
want.
let us see what
I want to
happened.
bring to record by, because this is not a simple section 11 application. I was praying for leave to file an affidavit. Are you opposing the affidavit? Anyway.
Well, let there be a short affidavit, my lord, if my learned friend insists. But my
So I have to
question
bring
is
the
that
record.
my right is being deprived at all stages.
No, Mr. Sen, I may agree with you, provided I agree on the law.
Yes, I'll show you.
Don't
Just
go on
give me,
the facts so
give me-
much.
give me 5
Because that will be against, that will be counterproductive.
Give me 5 minutes, my lord. If you're
No, you've affidavits come back by Friday, Mr. Mitra file. Yes, the,
Supplementary affidavit with the development agreement may be taken on record. Your lordship was pleased to.
have you served?
Yes.
The,
Only thing is, sorry for the interjection. Not Friday law. It will come on to me. Gives me slightly longer.
come on to me
So to draft it and churn it out by Friday, the affidavit gives me slightly longer.
by Monday.
Very good.
Yes, the petitioner and the respondent number 2 are brothers. Stop. The father of the petitioner and the respondent number 2, the late father of the petitioner and the respondent number 2 entered into a development agreement with the respondent number 1, which is the subject matter of the present dispute. Stop. The respondent number 2 is also the executor of the will of the deceased father. Stop. The petitioner claims that the respondent number 2 is with the respondent number 1 developer for the with regard to the dispute brought before the court. Stop. The petitioner also claims that the petitioner has been excluded from a pending reference before a sole arbitrator. Before a learned sole arbitrator, esta capital হবে, sole arbitrator between, which is continuing between the respondent number 1, between the first and the second respondents. Stop. The petitioner has filed an application challenging the jurisdiction of the arbitrator, and the same is pending consideration. Stop. Next, the respondents seek to file affidavits to the application to bring on record certain facts. Stop. Both of you want to file? Yes, affidavits in opposition, the affidavits in opposition will be filed by 11th September 2023, reply by
3 days.
reply by 15th is 5 days. Reply by 15th September 2023. List this matter on 18th September
My
2023.
lord, I did not want to interrupt. My lord had recorded that the development agreement was entered into by me and my late father. My lord, it was only my late father and the respondent number 1. My lord had recorded respondent number 2 and my deceased father. My lord, towards the beginning of
Yes,
the
yes.
order, my lord.
Development agreement entered into between the respondent number 1 and the deceased father of the petitioner and the respondent number 2.
Should be petitioners everywhere.
Okay, sure. There are more than one. Yes. যেখানে petitioner বলেছে সেখানে petitioners করে দেবে।
And my lord, the section 16 application was not challenging the jurisdiction for adding me as a party.
That's why I wanted to bring it on record.
Yes,
That's
for
why I
adding
bring
me
it
as a party.
So
Of course.
এখানে বললাম filed an application challenging the jurisdiction, not a application for impletement. Our shop petitioners for the supplementary affidavit is taken on record.
Okay.
I don't know, 14, whether India, tire and rubber.
Lordship, I appear on behalf of the respondents. I was just humbly seeking for a time to file affidavits in the matter, my lord.
My lord, I'm for the petitioner, my lord. This is my application under section 11, my lord.
Yes.
My lord, the dispute between the parties arise out of a manufacture and supply agreement, my lord, of 2002. My lord, I am India Tire. I am the buyer, my lord, in the agreement. My lord, the arrangement was that the manufacturer, which is respondent number 2, my lord, will manufacture industrial hoses in Turkey. My lord, and the respondent number 1 was the indenter. The indenter would import.
What is indenter?
My lord.
What is indenter?
My lord, indenter is the importer, my lord. The purpose was respondent number 1 would import the industrial hoses from Turkey as per the purchase orders placed by me. My lord, the agreement expired on 31st of March 2022. My lord, after the expiry of the agreement, the respondent number 1 is continuing to sell the hoses. My lord, I preferred an application under section 9 before the commercial court and I obtained an injunction order, my lord. From that injunction order, my lord, the respondent number 1 preferred an appeal before the division bench of this.
Tell the court what the order was.
My lord, an injunction order was granted on 18th of May 2023, my lord, annexure D at page 37, restraining the respondents from selling the industrial hoses in the open market because of the expiry of the agreement, my lord. The injunction order is still subsisting.
So what is the dispute?
My lord, the dispute is that they are continuing to sell the hoses. My lord, they preferred an appeal from this injunction order before the division bench of this court. My lord, it is admitted that the agreement has expired. That is recorded in the order of the division bench, my lord. The division bench of this honorable court appointed a receiver, and the receiver has filed a report after taking inventory of the stocks.
You don't need to say anything about the arbitration clause.
Yes,
nothing.
my lord, I'll place
About a
the,
section 21 notice, I have to tell you what to
my
say.
lord, I'll place the section 21 notice, my lord. I had sent the section 21 notice to the respondents on 20th June of 2023. My lord, there was a 30-day time period within which the respondent had to respond. So that period expired on 21st of July, my lord. After expiry of the agreement, I communicated to the learned sole arbitrator for constituting the arbitral tribunal. My lord, after that, after expiry of the 30-day period, the respondent had sent a notice to the arbitrator that they don't want to proceed with the arbitration. They don't want to participate in the arbitration because of the pendency of the section 9 proceedings, my lord.
Yes, you're representing both the respondents.
Yes, my lord.
Yes. What is the dispute? Tell me. Tell me. Hurry up, hurry up.
My lord, the dispute is, my lord, the agreement is at Annexure A, page 13, my lord. So, my lord, the arrangement is at clause 2. My lord, I am the buyer as per the agreement. The respondent number 1 was supposed to import the goods, my lord. The clause 2, my lord, is the arrangement. My lord, the buyer appoints Milan.
Are you ready to argue or not?
Yes, my lord.
Yes. So then hurry up and place it properly, please.
Clause 2.1, page 15 of my petition is the is the clause, my lord, the relevant clause. India Tire, which is the petitioner, appoints Milan Tube as indentor on a non-exclusive basis, and the indentor accepts such appointment. My lord, the indentor agrees that they will not indent, manufacture, sell, or supply similar products carrying the brand name Dunlop or any party either during the pendency of this agreement or even on completion or termination thereof. My lord, so the agreement had expired. The term of the agreement is at clause
But I
3.
don't understand. What is that they will not, what were they allowed, what were they supposed to import?
My lord, they were supposed to import the industrial hoses, my lord. The authorized product is at clause 1.1 at page 15. The authorized products as per this agreement is the industrial hoses.
Yes, so how is Dunlop coming in?
My lord, I am the authorized user of the brand, the trademark Dunlop. The arrangement in the agreement was that the respondent number 2 will manufacture these industrial hoses in Turkey. They would affix my trademark, which is Dunlop. And then the respondent number 1 will import these products from Turkey to India as per the purchase orders placed by me.
Yes, but clause 2.1 says indenter agrees that they will not manufacture, sell, or supply carrying the brand name Dunlop for any other party during the pendency of this agreement. So they would do it only for you.
They would do it only as per my instructions. When I place the purchase orders, they will only do as per that purchase order. My lord, the agreement had expired.
Yes.
My lord, the arbitration clause in the agreement is at clause 14. My lord, which is at page 32. My lord, the venue of the arbitration will be at Bangalore. My lord, the clause, jurisdiction clause is at clause E, which is at page 32. Where the courts of Bangalore are, there was subsequently a change in the clauses, my lord, which is at Annexure B, page 35. On 20 March 2009, my lord, the clauses were changed. The venue of the arbitration and the court of jurisdiction, clause 14 and 15E, was changed to Calcutta from Bangalore. My lord, this agreement was extended from time to time. Lastly, it was extended on 27th of December 2021. And the agreement expired on 31st December 2022. My lord, Annexure C is the renewal letter at page 36, which says that the validity of the agreement.
When did the agreement expire?
My lord, it's at Annexure C.
Don't read from your notes. You have to show the documents.
Annexure C, my lord, page 36.
What is page 35? You're just parroting your notes, whatever you've got written down.
My lord,
What is 35?
Page 35, my lord, is the renewal of the agreement of 20 March 2009. And the clauses of the agreement were changed. Clause 14 and 15E, which is the arbitration clause.
20 March?
20 March 2009, my lord. After 7 years of entering into the agreement.
And when did it expire?
My lord, the expiry is on 31st of December. My lord, Annexure C, page 36.
31st of December?
31st of December 2022, the agreement expired. This is the last renewal letter dated 27 December 2021.
Where does it say that it's going to expire?
My lord, the second line, now we are pleased to extend the validity of this agreement up to 31st December 2022 with all terms and conditions remaining the same.
Yes, what happened after this?
My lord, after the expiry of this agreement, the respondent is continuing to import the hoses even though they don't have any purchase orders from my end, and they are selling these hoses in the open market. My lord, thereafter, I preferred an application under Section 9 before the Alipur Commercial Court. My lord, the order of injunction is dated 18th May 2023. It's at Annexure D, page 37. My lord, page 41 is the order. Considering the gravity of the present case, this court deems that the petitioner is able to prove a prima facie case in its favor, and the balance of convenience is also titled in its favor. As such, relief is granted by way of ad interim form in respect of prayer A. My lord, this order is still continuing. My lord, thereafter, they preferred an application under an appeal before this honorable court. My lord, the division bench order is at page 58, Annexure F. My lord, 27 June 2023. My lord, the division bench did not interfere with the order of the Section 9 court. My lord, a receiver was appointed and the appeal was disposed of. My lord, page 61. My lord, two observations. My lord, page 60. Seventh line from the end, my lord, the division bench observed that prima facie it appears that the agreement expired on 31st December 2022. My lord, page 61.
Where is your 21 notice?
My lord, section 21 notice is at page 64, annexure G, my lord. I had sent the notice on 20 June 2023. My lord, there was a 30-day time period, which is at page 66, my lord. They had received the notice on 21st of June 2023, and the 30-day time period had expired, and they did not object to the commencement of the arbitration proceedings.
And what is page 74?
My lord, page 74 is their letter from the advocate of the respondent number 1 dated 27 July.
So you don't think that you should place this letter? It's a reply by them.
Yes.
Then
My lord, this reply they had sent after the expiry of the 30-day period.
that's regardless.
Yes.
You're placing a section 11, you have to place the letter.
Yes, my lord.
If the court does not find out the documents, it will just keep quiet. Yes, what do you have to say?
My lord would kindly come to the order of the division bench challenging the section 9 application at
Yes,
page 61, my lord. Sorry, my lord, at page 60, bottom half if it comes, my lord. Page 60, bottom half.
yes.
Last, my lord, undoubtedly, comma, the petitioner would be entitled to use these stocks. The petitioner in the instant case with the respondents 1 and 2 here, my lord,
Yes.
would be entitled to use the stocks for which royalty has been paid. Moreover, the respondent cannot resile from their undertaking to purchase the entire stock in terms of their communication dated 29th April 2023. Now, my lord would kindly skip the next part and come to the last paragraph. Both the parties have prayed for appointment of receiver in order to visit the warehouse of the respondent number 1 with the address such and such, to survey the premises and make an inventory of the stock of the product with the trademarks Dunlop and Dunlop D device, only mentioned in prayer D of the application. So, my lord, the reference which my learned friends today are seeking for is in regard to the infringement of these two devices only, my lord. This is already part of
Half the documents you haven't even shown. What about page 79? And in any case, both the pages mention two page numbers. What is page 79 or 83?
My lord, page 79 is the communication from the respondent's advocate to the sole arbitrator.
Yes. The present application is for appointment of an arbitrator under section 11 of the 1996 Act. Stop. The some of the documents were placed for the court's perusal, comma, the court had to search out the rest. Stop. Next, the dispute. Next, the dispute arises out of an agreement, a manufacture and supply agreement dated 5th March 2002, entered into between the parties, wherein the petitioner has been described as the buyer and the respondent number
One is the
number one is the, please show me the clauses, Mr. Yes. And the respondent number one as the indenter, quotation marks, INDENTER, close quotation marks. Stop. And who is this,
and the
respondent number two?
my lord, respondent number 2 is actually my Indian counterpart.
Yes,
who
the respondent number one appointed the respondent number two as its
manufacturer. my lord.
as its manufacturer in Turkey for taking the agreement forward. Stop. Next. The by the agreement, comma, the respondent number one was to market and was to sell and supply products.
My lord, the respondent number 1 was supposed to import the goods which were being manufactured.
Very
by
well. The respondent number one was to import the goods manufactured by the respondent number two, carrying the brand name Dunlop. Quotation
Dunlop
marks.
D device.
Dunlop. Stop. The petitioner claims to be the authorized user of the said brand name, of the Dunlop brand name. Stop. The agreement, next paragraph, the agreement was a fixed term agreement which was renewed from time to time, and the last renewal on record is of 20th March 2009. Stop.
My lord,
The
last renewal letter is dated 27 December, my lord, 2021.
27 December, when March, 27 December 2021. Stop. The letter written by the petitioner to the respondents clearly stated that the validity of the agreement was being extended to 31st December 2022. Stop. This agreement contains an arbitration clause. Stop. Next, admittedly, comma, the agreement expired on 31st December 2022 without further renewals. Stop. The petitioner claims that the respondents, however, continued to sell and market products bearing the brand name Dunlop in the open market in contravention of the terms of the agreement. Stop. The petitioner approached the commercial court at Alipur and for interim relief and obtained an order.
Order is at page 37. my lord.
And please, I will ask you, and obtained an order on 18th May 2023 in terms of prayer A of the application, which is, where is prayer A?
My lord, the application has not been annexed by my lord.
My lord, the prayer is quoted in the order, my lord, page 37, Annex to D, The prayer is quoted in the bottom line. Prayer A for passing an order of injunction restraining the respondents, their proprietors, partners, or
Yes,
directors.
prayer A of the application, namely that the respondents would be restrained from selling and marketing products which form the subject matter of the agreement. Stop. The respondents challenged the said order. The respondents unsuccessfully challenged the said order, and the appeal was disposed of by a division bench of this court on 27th June 2023. Stop. The petitioner thereafter invoked the arbitration clause by way of a notice under Section 21 of the 1996 Act on 20th June 2023. Stop. The respondent replied on the reply to this letter on
My lord, and page
27 July 2023, 27 July 2023. Disagreeing with did you disagree with the choice of the arbitrator?
No, my lord, we disagreed with the whole arbitration process.
Yes, disagreeing with the entire arbitration process. Stop. The respondent objected to the appointment of the learned arbitrator on the ground of proceedings pending before the commercial court at Alipur. Stop. The petitioner thereafter took steps for initiation of the reference, and the respondents objected to the same on
27 July 2023, my lord, page 79.
where is the where it's not page 79. Where is the letter where you wrote to the arbitrator?
My lord, page
My lord, page 79.
79 or 83? There are two sets of numbers on every page.
No, my lord, in my set it's 79.
My lord, page 79, my lord, letter dated 27 July 2023 to the arbitrator.
The 83 letter is, my lord, their letter, my lord. Our letter is at page
And the
79.
respondents objected. And the respondents also wrote to the arbitrator opposing the reference. Stop. Next. The dispute between the parties would be apparent from the fact that the petitioner alleges the respondents continuing with the terms of the agreement after expiry thereof on 31st December 2022. Stop. The respondents in turn point to the observation of the division bench of this court, which
Page 60, my lord. Page 60 and 61, my lord.
observations made by the division bench in the respondent's challenge to the order passed by the commercial court at Alipur. Stop. The order passed by the division bench itself reflects the continuing dispute between the parties. Stop. The whether the respondents are continuing to breach the terms of the agreement despite expiration thereof, or claim any substantive right to continue with the terms of the agreement would depend on the outcome of the arbitration proceedings following appointment of an arbitrator. Stop. Next, there is no dispute that the respondent has also, there is also no dispute to the fact that the respondent has replied to the section 21 notice by objecting to the initiation of the reference. Stop. Next, the material placed before the court are sufficient for the court to come to the considered view that there is an existing dispute between the parties, which arise out of the arbitration agreement contained in the arbitration clause contained in the agreement dated 5th March 2002. Is it 2002?
2002,
2002. Stop. Prathomta bodhoy 2002 bolini ekhane. Next, AP number 601 of 2023 is accordingly allowed and disposed of. What is the claim?
The claim is that, my lord, in the page 66, my lord, my claim is under 3 heads, my lord. One is due to the breach of the agreement.
What is the total claim?
The total claim amount would be around 159 crores.
My lord, just 2 things, my lord, before my lord. The section 9 for final disposal has been kept tomorrow before the.
Very well. Yes, by appointing is disposed of, allowed and disposed of by appointing blank to act as the learned, to act as the arbitrator, subject to the learned arbitrator appointing, communicating his consent in the prescribed format to the registrar original side of this court. Within 3 weeks from date. Stop. The advocate on record of the petitioner shall communicate this order on the learned arbitrator by 7th September 2023, along with the requisite details of the contact person, the arbitrator. Stop. Next, counsel appearing in this matter are expected to be ready, are expected to be more prepared in while addressing the court in future matters. Stop. Grateful. Next.
Item number 15 with item number 16, Fazlur Rahman and another versus Pay Equipment. I'm appearing for the petitioner. I'm being led by Mr. Sayyid Huda. I'm praying for not putting.
It's your 11. Yes, adjournment is prayed for on behalf of counsel appearing to the petitioner. Stop. List this matter tomorrow. Next.
Appear for the response. Grateful. Item number 17, Tata Steel Brown Products. That I appear for the award debtor regard section 34 application. On the last occasion, the section 36 application had come up, Lordship, and we were directed to take instructions. Malad, we'll put in, we'll secure the money. The award sum, Malad, it will be about 8 crore 13 lakhs. Yes. Malad, only by way of bank guarantee. Malad, with that, there is one submission, Malad. The section 34, really speaking, revolves around a very short question of unilateral appointments. A settled position, my lord. If lordship permits, that's also appearing in the list as item number 37.
So first you put in the money, then we shall see. And half by cash, half by bank.
My lord, may we be permitted to do it by way of bank guarantee, my lord?
No,
Lordship had allowed it on a previous occasion.
Maybe I've changed my mind. Yes, and how much is the time you will take?
Well, it's 4 weeks.
4 weeks. Yes. And how do I know that this is the awarded amount?
My lord, that will be the awarded amount, my lord. We filed an execution application where we, my lord, claimed 8.12 crores. So, my lord, 8.12.
No, give me the page, please, Mr. Mukhopadhyay.
My lord, here they haven't stated, my lord. It's in my execution application, my lord. I can.
No, this petition doesn't disclose the awarded amount.
My lord, it discloses the award sum, my lord. The award is annexed, but the awarded sum today, my lord, including interest, post-award interest is not disclosed, my lord.
So how much is that? 8 crores?
8 crores, 13 lakhs, my lord, approximately.
Very well. Learned counsel appearing with the petitioner submits upon instructions that the petitioner will secure the awarded amount, which today is approximately rupees 8.13 crores, Stop. Next, AP 539 of 2023 is accordingly allowed and disposed of by directing the petitioner to secure the amount of rupees 8.13 crores. That is approximate, or that is the exact amount, the 8.13 crores?
That is approximate, my lord, as on, my lord.
Give me the exact
31st
amount.
July. My
As
lord,
on,
As
as
on
on-
18 July 2023, my lord, it was 8,12,28,000. That is, my lord, 8 crores.
very well, awarded amount of rupees 8,12,28,000 as of 31st July 2023. At a first line, stop. Next, AP 539 of 2023 is accordingly allowed and disposed of by directing the petitioner / award debtor to pay 50% of rupees 8,12,28,000 by way of cash deposit, and the remaining 50% by way of bank guarantee with the registrar original side within 8 weeks as proposed from tomorrow, i.e. 5th September 2023. Stop. The award will be stayed from the operation of the award will be impugned award will be stayed on and from the day following the full payment made by the petitioner / award debtor to the registrar original side. Stop. Next, in the event the petitioner defaults on the directions stated above, comma, the award holder shall be at liberty of executing the award. Stop.
But, I'm sorry, Malad.
Yes.
Malad, that section 34, Malad, will recall, Malad, the point, Malad, is with the Perkins, Malad, point, Malad, it's a unilateral appointment.
Yes, yes.
So, Malad, if Malad wants, Malad, we can also, Malad, start on that, because, Malad, originally, Malad, that application.
Is the 34 already also in the list?
Yes, in the list,
that's
my
all.
lord, as
I think
item
that-
37.
Malad, when it, because, Malad, in fact, both were, Malad, directed both to appear together, Malad, so that we could take instructions.
And my
Malad,
lord,
I understand, Malad, without, Malad, perhaps
No,
security.
I
Malad.
will put the 34 after 8 weeks, or you pay the amount within 2 weeks. I will hear the 34.
Malad, in fact, 34 application was taken up for hearing. Malad.
Very well. So I will give a shorter date, not 8 weeks. All right, 8 weeks is as your learned junior told the court, informed the court.
Malad, kindly, Malad, then give us, Malad, 4 weeks, Malad, we'll, Malad,
How
secure
did
the
it
amount.
8 weeks, Bola, what 4 weeks?
So,
for?
unilateral appointment, Malad, that's why, Malad, it was taken up. Malad,
Yes,
section
yes.
34 was taken up.
List the 34 take list run, please.
item 37, my lord.
Yes,
And Malad-
30, 17 and 37.
And Malad, the execution, Malad, can also, Malad, then put it, Malad,
My
after
lord,
that.
in respect to the section 34, my lord, I had one
Mr.
small.
Mukhota, move the microphone, please.
My lord, in respect to the section 34, my lord, I had one submission, my lord. My lord, then, my lord, they haven't annexed the entirety of the pleadings. They've craved leave to, my lord, file it in
No,
court.
no, I'm not putting the,
My
I'm
lord.
just see what
My
I'm
lord.
doing. Yes, যেটা 8 weeks বললাম 4 weeks করে দাও। And list the list AP
189.
189 of 2023, comma, which is the section 34 application on September 2023. Stop. The petitioner in AP, যেটা বললাম last AP টা, will be at liberty of filing. You want a supplementary affidavit?
My lord, for the entire records of the
So,
arbitration
section 34,
tribunal are
Malad,
not-
was taken up for hearing. It's really, Malad, that point,
Very
short point, Malad, on
The
the.
document.
Malad, unilateral appointment, Malad, is really, Malad, the issue. Readings are complete, Malad, in that.
Very good.
Malad, Malad, may I just request, Malad, 28th instead of 27, Malad.
এটা কবে বললাম?
27, Malad, directed, Malad, instead of that, Malad, 28th is a Thursday.
27th, 28th. করে।
20th, I'm grateful.
Yes, next matter, please.
And, Malad, the execution, Malad, can also, Malad, come up because we'll, Malad, obviously, Malad, secure, Malad, the amount otherwise.
That is also in list, my lord. That is item
Yes,
2.
the execution application, the respondent award holder will be at liberty to mention the execution, the parties. The parties will be at liberty. ওটা কি আছে? It's in the Yes, the parties will be at liberty of mentioning the execution application for listing in the week beginning 25th September 2023.
Wait.
Let's call on the next matter.
Item number 18, Hooghly Mills Project.
Yes.
This is an application under section 29A. My lord, I would beseech your lordship to keep it after 12th. My lord, the reason being
After?
after 12th. On 12th, my lord, a connected application is appearing. Here, my lord, lordship is considering that, my lord, whether the arbitrator can stay his own proceedings. Last Friday, lordship had heard it.
So, but then how is it a 29A?
My lord, this is because after that, the mandate had expired. And my lord, I am indicating clearly, my lord, this has been done after the mandate has expired. But my lord, what is the effect when he has?
What has been done?
My lord, this 29A has been filed only in 2023.
Yes.
Whereas his mandate had expired in 2022, but we had challenged the order where he had stayed his own proceedings. I understand my learned friend wants to file an affidavit. Let the affidavit be complete, and my lord, lordship is taking the other application on 12th, my lord. Let this be taken up after that, because if we are able to, my lord, get that order dislodged, I would try to beseech your lordship that this will fall in a different.
And that other order is in a 34?
No, in the 37 appeal, my lord, in an application in the nature of section 17, the arbitrator stayed his own proceeding. That application was made when, my lord, the mandate was alive.
Very good. Yes. And when is the other matter coming?
Lord, that is coming on 12th of September. In the meantime, if my learned friend wants to file an affidavit, my lord, please.
Yes, learned counsel appearing for the petitioner seeks to have the matter listed on after 12th September 2023 on the ground that an application on the ground that an appeal filed under section 37 of the 1996 Act is being will be considered by the court on 12th September 2023 involving a similar issue, which is
The issue is whether the arbitrator could stay his own proceedings.
a similar issue, namely whether the arbitrator could stay his own proceedings. Stop. Next. List this matter on 13th September 2023 as prayed for.
In the meantime, your lordship, if it is required, we'll fight.
Yes, the respondent will be at liberty, affidavit in opposition
Within 2 weeks.
within 2 weeks, within 2 weeks, then it will
1
go
week.
beyond
Your-
13th.
I understand. Then 1 week. 1 week. Your lordship.
Yes, affidavit in opposition within 11th September 2023. Reply, if any,
3 days.
by within 14th September 2023. তাহলে 13 না 14 করে দাও। List this matter on 14th September 2023.
I'm grateful.
Mr. Chaudhary, 14th will be a short list. So I can put this matter on 18th if you want.
18th.
Yes, affidavit in opposition by 12th September 2023. Reply by 18th September 2023. List this matter on 18th September 2023.
Item number 19.
It's a similar matter, my lord. 4 connected matters are there. AP 520, same one. Kindly keep it on 18th.
But Mr. Chaudhary, why do you want this matter to be heard after that, taken up after that other matter? What is the logic?
Lord, the logic is this, my lord. If we are successful, my lord, in showing that, my lord, the arbitrator could not have stayed his own proceeding when the mandate was alive, then, my lord, whether lordship will, different consideration will arise so far as section 29A is concerned. Because, my lord, we could not do anything, my lord, at that period at the instance of my learned friend's client who filed the application, which was heard. Hearing was concluded also when the mandate was alive and he stayed his own proceeding. So what is the effect of that
So
stay?
why would the arbitrator stay his own proceedings?
My lord, according to us, my lord, we would submit that.
This is the one which Mr. Sen was arguing.
No, my lord, Mr. Dotto was arguing on last Friday.
Yes. I'm sorry, Mr. Dotto, not
Mr.
Mr. Sen.
Dotto was arguing last Friday.
Yes. That there are three agreements.
3 agreements. Your lordship.
The Lordship will recall the eviction award already passed section 34 pending. There are three connected applications.
Because of some pending proceedings in
Yes,
this court.
maintenance and all, my lord, they said that since until and unless the eviction 34 is considered, you can't proceed with that. And the learned arbitrator agreed to that view and he stayed his own proceeding.
Very
So, my lord,
yes,
what
yes.
would be the
I
impact
remember
of-
now, yes. Same order. So you want to argue what? That the mandate will be deemed to continue?
No, my lord, I would argue that had he not stayed the proceeding, my lord, under normal course, we are within the, my lord, original 1 year period. So, my lord, by consent, the 6 months, we would have got the 6 months and, my lord, this would have been.
No, by, how do you assume consent?
Because, my lord, when the stay application was made, it was much within the 1 year period.
Yes, but
Yes.
but 29
That is why, my lord,
doesn't
we have
doesn't
asked for
follow
the
automatically.
affidavit. My lord. Let us see what
Very
this,
good, yes.
they will take a stand one way or the other.
Yes. Follow the next matter, please.
20.
Same matter, similar matter.
Same order,
And another one is 530.
Item number 21.
same order.
Grateful, Your Lordship.
So who has a lack of legal acumen in this matter? Who?
But in the meantime, we are hopeful Lordship's judgment will also come.
That's Your Lordship. That's why Your Lordship.
That
we
is
want
also
chapter 30.
another reason, my lord, we will, because, my lord, I'll be very candid, my lord, there are two ways.
Wednesday. Delivered on Wednesday. Will be delivered on Wednesday.
Because, my
Just
lord,
taking too much time to correct.
no,
that's
it's all right, my lord, whichever way my lord holds, my lord, all that I have to do is, my lord, it will either be a fresh mandate under section 1415, an application under section 1415, or, my lord, this will be that. That's all, my lord. It will only be a course of action which we'll have to choose. Whatever view my lord takes.
Very
Definitely. In fact, we are aware of my lord's view. We will just have to go through the reasons.
No, I depends on the day. I constantly change my views. Yes, next.
Twenty-two, Hooghly River Bridges Commissioners versus MBL Infrastructure.
Yes.
Lord, I'm opposing this section 34.
Why do you want to pass over, Mr. Ray?
Dotto is leading me, my lord. If you're
Sorry?
Mr. Dotto is leading me, my lord. My lord, on the last occasion, he started his submissions, my lord. If your lordship allows that audits, but I'll continue.
No, no, you start. It's a 34.
Yes, my lord.
Yes. Mr. Doctor, please take your seat for a while. Yes.
And he says he can't be seen because of my. Well, this section 34 application, my lord.
Yes.
My lord, we are challenging, my lord, on the ground of perversity. My lord, there are 5 basic grounds, my lord. One is the finding by the learned arbitral tribunal that time is not the essence of the contract.
What was the contract?
Yes, my lord. The contract, my lord, the construction of, my lord, bus terminal.
Yes, yes, yes. I remember. Yes. In Srirampur?
In Srirampur, my lord. So, my lord, that is the basic scope of the the contract between the parties. And, my lord, there this finding was that the claim is not the essence of the contract. Primarily because, my lord, that the well-spun theory, my lord, if you touch it, my lord, that liquidated damages clauses in contract, it presupposes that time is not the essence of the contract.
Yes.
And thereafter, my lord, LD not being imposed during the extension of time would result in a presumption that it was extended justly.
Extended?
Justly.
Just.
And therefore, HRBC, or rather the petitioner, had accepted its faults and condoned the delay. This was the ground on which the award has been passed. Now, my lord, for that, my lord, your lordship will kindly, because this is the first point of the extension part, my lord. My lord, may I be permitted to first place the clause?
No.
No.
Tell me the outlines of your arguments, how you plan to tackle the law.
My lord, I would first, my lord,
Hand up the phone, please. Yes.
no, no, Guru.
Yes. Yes, Mr. Ray.
My lord, I will be saying that the finding is contrary to the understanding between the parties.
Yes.
And primarily the liquidated damage was never waived by the petitioner. Now, if it is not so, then my lord, the finding is perverse. If I can show it from the contract itself and as well as the documents which has been relied upon by the learned tribunal. So this will be my first point of argument on the extension of time and not
imposing the
imposition of
LD
the
clause.
liquidated damages clause. And thereafter, my lord, there are other.
So what was the view of the tribunal? Why did the tribunal hold that time was not of the essence?
Because, my lord, there were extensions granted and liquidated damages was not imposed.
Those were the two reasons. And you're upset with that only?
No, my lord, there are other grounds, my lord, also. Is one of the upsetting features, my lord.
What are the other grounds?
My lord, the holding that the termination of the contract was wrongful.
Yes.
Because, my lord, first of all, my lord, there was no challenge to the termination. In the statement of claim, there was no challenge to the termination.
Yes.
So I would humbly submit that it was beyond the reference. But one thing is reference under section 21 and the reference under statement of claim coupled with the section, this gives a different view altogether. So since there was no claim, my lord, the arbitral tribunal, having ventured to hold that, my lord, has acted, my lord, in a perverse manner. My lord. Humility, I submit this, my lord. Then, my lord, there is a point, my lord, on waiver of notice to commence the work, my lord, that the same was subject to the municipal laws. This finding is also, my lord, contrary to the contract, my lord. I'll show the clause just to show.
28.3.
Yes, my lord. My lord, 28.3, I do appreciate, my lord, it's not to the T that everything has to be followed. There's a scope for interpretation. And this interpretation could not have been reached, my lord. If there is a literal
So
construct.
not even a plausible one?
No, my lord.
Impossible one?
Impossible one. Because this is something contrary to the
Parties
contract.
could never have intended that.
But I submit, but if there is something which is absolutely contrary in the contract, then there is no scope for an interpretation. And there was no such understanding.
And the arbitrator is not the correct person to do that.
My lord, if it is a plausible interpretation, definitely, my lord. But if it is not plausible, your lordships have laid down the law. It has to be yes. It was a plausible interpretation then only. And other than that, my lord, this was also beyond the reference. This point was also beyond the reference.
Very well. Yes, Mr. Doctor.
Yes. I'm very curious.
Mr. Ray, you assist Mr. Doctor, please.
Yes, it is. That I do.
But I believe, my lord, the award has been handed up to the court, my lord, separately. Kindly have a look to the award. But the relevant portion of the award.
Yeah, আলাদা করে দিয়েছেন কি awardটা? In the compilation?
Yes.
Yes. Yes.
But if your lordship may kindly take me out the internal page, since the award is separately given, my lord, page 47 of the award.
Page 47, the
Bottom.
number at the bottom of the page. Have you given a copy to your learned friend? Mr. Dotto, to Mr. Banerjee?
Yes. Yes.
Yes.
It's running page 2943,
Yes.
paragraph 12. From the above provisions, my lord, the tribunal quotes, my lord, clauses 27, 28, 29, 49, 56, 59, and 60. And then, my lord, paragraph 12. From the above provisions of the contract, it is clear that although it was specifically mentioned that the time would be the essence of the contract, in view of the existence of the provisions of extension of time of performance for various reasons and the provision of imposition of liquidated damages, in the opinion of this tribunal, it should be accepted that time was not really the essence of the contract.
So there is no question of a majority award here. There's
No.
just one award. Yes.
Unanimous. Then, my lord, the tribunal, my lord, quotes from Halsbury's. Kindly skip over the quoted portion and thereafter. The above principles for ascertaining whether time is the essence of the contract has been approved by the Supreme Court in Hind Construction.
Yes.
Then, my lord, paragraph number 13, I'm sorry. The termination clause provided in the contract specifies the circumstances under which the agreement may be lawfully terminated by the employer. Therefore, it is the duty of the employer to justify the order of termination by showing that the conditions for termination as specified in the contract existed in the present case, and the initial burden is upon the respondent to show that while terminating the contract, it complied with the provisions mentioned therein. Well, I'll take up this termination issue later on. It further appears that there is a clause for extension of time for completing the project where various conditions are mentioned indicating the circumstances when it shall be the duty of the respondent to extend the time of performance. There is also provision empowering the employer to impose damages upon the contractor in case of delay on the part of the contractor without any just cause. The aforesaid three factors, if taken together, make it clear that if the respondent has on the prayer of the contractor justifying extension in terms of the contract, extended the time of performance without imposing any damages for the delay, it would necessarily follow that there was just cause for extension of time. In other words, once having extended the time for performance on the prayer of the contractor, even without imposing damages for delay, subsequently the employer cannot turn around and contend that there was no just ground for extension in the past, and that the time was earlier extended as a matter of grace. It may not be out of place to mention here that in the contract between the parties, there is no provision for granting extension of time without imposing damages for delay without notwithstanding the fact that there was negligence or inaction on the part of the contractor. The employer, in the opinion of this tribunal, in such a situation will be stopped from disputing the existence of the just ground for extension after having induced the contractor to continue and spend money for further construction, and the contractor, by relying upon such inducement, having proceeded with the work by spending further amount of money from its own pocket for further completion of the project. This tribunal is quite alive of the fact that in this case, in the orders extending the period, the phrase without prejudice has been mentioned in case of the last two extensions. My lord, pausing here for a moment, my lord, the tribunal skips over, my lord, those letters where, my lord, we have specifically said that your reasons for a delay are not acceptable to us, but still we are extending it without prejudice. And the last letter, my lord, I'll place those.
Mr. Doctor, you place it, but prima facie, the reasoning seems to be quite perfect.
My lord, the reasoning, my lord, in my very respectful submission, my lord,
yes,
if it is, my lord, dehoards the documents on record, then, my lord, I can challenge it on the grounds of perversity. as your lordships have held, my lord, the various grounds on which, my lord, an adjudication can be held to be perverse. One of the ground is that if relevant evidence is not taken into consideration. But the letter is taken into consideration. I won't say that the letter is not taken into consideration, but the relevant part of the letter to come to this conclusion that there was just ground for extension, in my humble submission, was not taken note of.
And your letters which you say were not considered say what? That I am extending the contract, but
your grounds for delay or your excuses for delay, if I may put it in this way, are not acceptable to me. Therefore, my lord, the tribunal could not.
But you extended nonetheless.
Because I have to get the work completed.
Yes.
The purpose is to get the work complete, my lord. But my lord, why we terminated? The termination was, my lord, after the last extension, there was only 3% of the work done. But I'll take your lordship through that. And next is the other part is termination was never under challenge, as my learned friend Mr. Ray has said. Not only that, the last letter, which is post termination from the side of the claimant, they specifically said that please allow me some more time to complete the work, which means that the contractor is insisting to carry on with the contract. That has a legal effect. May I proceed further, Miller? Last two extensions. But in the opinion of this tribunal, writing of such a phrase by the employer in the order refixing a date of completion is of no consequence. It is now well settled position of law that if the above phrase is used in any offer by any party to the other, and such offer is not accepted by the latter, such offer will not prejudice the right of the former. But position will be completely different. The next part, again, in my very humble submission, is legally erroneous. That is, but the position will be totally different if the offer given by the former is accepted by the latter. In such a situation, a fresh, complete contract would be formed with the extended date of completion, and the offer, although given without prejudice, will operate to the old, alter the old state of things and to establish a new one. We're pausing here for a moment, my lord. My lord, when an extension is granted, in whichever field, in whichever contract, but extension is primarily, my lord, expanding the time.
Yes.
Yes. Or in other words, my lord, my learned friend, my lord, gives a apt example that when your lordship extends the time under section 29A for the arbitral tribunal to conclude the award.
Without prejudice.
Without prejudice also, then what happens? The statutory period is 1 year and 6 months. My lords are only expanding the period from 1.5 years to say the next 3 months, 4 months, whatever. So therefore, it cannot be said that when there is an extension, it gives rise to a new contract or a new proceeding. It is only expanding the period. Purpose is novel, so that the person can complete the work. Therefore, this last finding of the tribunal, that when I extend it, it becomes a new contract and will operate to alter the old state of things and establish a new one. In my very humble submission, I'll make my submissions, I develop it on that. That way it doesn't, my lord, create a new contract. It is only a facilitator for the contractor to complete the work, because no employer finds any, what should I say, fun in, my lord, terminating the contract. That's why, my lord, we gave 4 terminations, 4 extensions. Because we wanted to get the work done.
And you did not impose LD.
I did not impose LD. But please consider, my lord, the tribunal proceeds on the assumption that the fact that I have not imposed LD is an indicator that I have excused their faults or condoned their delays. But that again, my lord, is possibly, my lord, again an incorrect, my lord, interpretation, because the liquidated damages clauses, my lord, are put into the contract. The purpose is to have the work done and have a commercial, my lord, viability. So this is the purpose, so that a person is put on the toes, that if he doesn't complete the work, he is to suffer in a pecuniary manner. May I proceed further? Madam? At this stage, it would be profitable to refer the classic interpretation of the above phrase by Lille LJ in so and so, so and so. Milord, your lordship may skip over that. Then please take, Milord, the next paragraph, paragraph 14. From the above position of law, it is clear that the employer in the present case was satisfied with the reasons shown by the contractor for non-compliance of the time limit initially fixed, and the time originally fixed was extended 4 times, and before the expiry of the 4th extended period, that is 30th of June, illegally terminated the contract, which is not permissible, and the ground mentioned therein are mostly of the alleged inaction of the contractor for the period for which the extension has already been granted without imposing any delay damages. Then, Milord, your lordship may kindly take, Milord, instead of reading the other paragraphs for the present, Milord, kindly take paragraph page 66.
Mr. Doctor, before you proceed any further, you tell me when you want to come back and continue.
Milord,
66, I will make a note of.
yes, 66 of the award.
Yes, tell me when.
Could it be next week, Milord? Tomorrow and the after, Milord, I'm not here. Friday, Milord.
You're taking a holiday from tomorrow?
No. Professionally busy, Milord. Could it be next Monday or Tuesday, Milord? Mr. Banerjee, could I help?
Tuesday, Tuesday, 12th.
Could it be 11th,
Yes.
subject to the
Yes, a learned counsel appearing for the petitioner / award debtor will continue with his submissions on 11th September 2023.
Could it be 13th? My junior.
13th September 2023. Stop list this matter on that date as paid for.
But the Senbo matter has been fixed by my lord tomorrow, my lord. Kindly accommodate me tomorrow.
Mr. Dotto asks somebody to be
Wait,
here in court
wait.
and remind the court.
I'm grateful.
Call on the next matter, please.
I'm grateful.
Item number 23 with 24.
Well, item number 23 is a 34 application, and 24 is a execution application filed by me. In 23, I'm opposing. I took the point of maintainability that this 34 application is not maintainable.
Yes, you come back tomorrow, all right?
Lord, I am the appointed receiver in this matter, my lord. Lord, may I
Yes, my
file
lord,
a
there is
report?
a
my lord?
direction I should indicate.
You're the receiver.
Yes, my lord.
Where is the order?
Lord,
Item number 24.
may I hand over the report, my lord, contain
Wait,
the order.
can't you see that the court is asking something? Yes, what is the order, Mr. Guho?
My lord, there was an order that was passed to hand over the vehicle to the respondents, since they have made over a payment of 7 lakh rupees.
Very
So
well.
we have handed it over, receiver has
This is in
handed
the
over.
execution application.
This is in the execution, item number 24.
23, the learned receiver hands up a report. Stop, let copies of the report be circulated amongst the parties. It EC টাতে হবে, EC. Next, তারপর এটা হচ্ছে AP 209/2023. No one appears for the petitioner. Stop, list this matter on, give me a date, please, Mr.
Well,
Guho.
any day convenient.
List this matter on, list this matter on 6th September 2023.
Grateful.
Mr. Guho, please inform the council.
I will inform.
My lord, No, no mentioning now on
My lord,
Thursday.
it's not about the mentioning. My
On
lord has
Thursday.
taken away my phone in the morning. It was really not intentional. I had.
Phone to फिर दे- Yes, call on the list. please.
Non-commercial matter. Item number 1, Rohitas Kumar Kothari.
My application, my lord, for appointment of an arbitrator.
Can't hear you.
This is my application for appointment of an arbitrator under section, this is an application under section 11, my lord. My lord, the petitioner has executed certain
Hearing it for the
civil
first
works.
time?
My lord, this is appearing for the second time. On the first time when the matter had appeared, it had appeared before a coordinate bench and had indicated that there's an existence of a arbitration clause, which is at page 31, my lord, and
Yes.
31 clause 24, my learned friend had sought time on the ground of taking necessary instructions with regard to agreeing to the arbitration. My lord, if I may indicate, my lord, there were certain purchase orders.
Where is the arbitration clause?
My lord, page 31. My lord, the confirmatory purchase orders. The purchase order starts at page 27, my lord, that's the second purchase order. And the first purchase order is at page 21. My lord, at clause 24 is the dispute resolution clause.
One arbitrator.
Yes, my lord. Under the venue, my lord, if I may place, my lord, it's
Yes.
in the event of any dispute or differences arising out of or in connection of the purchase order, such disputes shall be firstly attempted to be settled by mutual discussion. In case of failure on the parties to reach an amicable settlement within 30 days from the date of referring the dispute for mutual discussion, the
Yes.
disputes will be referred to arbitration. On failure of amicable settlement as mentioned in
No, no.
clause.
What is the dispute?
My lord, the dispute is non-payment with regard to services that has been rendered. Rather, my lord, the goods and services that has been rendered, my lord, I had issued a letter on 30th of December 2020, indicating that there are dues and for the purpose of settling the claims. But my lord, there has been no response. Thereafter, I have issued the letter under section 20.
You think that you're doing the matter before the same coordinate bench?
No, ma'am.
That you don't need to tell the
I
court
will-
the facts?
I will-
Or are you confused?
No, my lord. My lord, in terms of the purchase orders, thereafter I had supplied goods. My lord, all the invoices that I have raised are from page 32 onwards.
Tell me, what is the scope of the contract?
My lord, the scope of the contract was that they had raised purchase orders. I was required to supply goods with regard. These were mixtures which was required for
Yes,
the
the learned
purpose.
counsel appearing for the petitioner needs to get ready. List is
My lord, I will indicate, my lord, these are
No, no, no.
construction related work, my lord.
Any more than one question of the court? Adjournment
My lord, may
on the ground of counsel.
My lord, I was taking a preliminary point of maintainability, my lord, in this.
Yes, tomorrow, take it, tomorrow. Next,
I tender my apology, my lord.
next.
Item number 2, Dibyendu Bose.
This is my application under section 11. My lord, the contract was executed, my lord, between me and the railways. My lord, will kindly, my lord, take volume 1, page 22. My lord, there, my lord, I have enclosed the contract.
Yes, what is the contract?
My lord, the contract was for, my lord, supply, erection and testing and commissioning of 125 my lord, kilowatts and 1 PSI work in connection with a work of a freight terminal at Sankrel. My lord, my lord, do these electrification work, my lord, at these railway terminals. My lord, a tender was issued. My lord, I was the successful bidder. After that, my lord, this contract was entered into. Now, my lord, this contract was, my lord, contained an arbitration agreement. This arbitration agreement, my lord, is at page 249, volume 2.
Last time you had said 244.
Yes, my lord, there was a, my lord, mistake in the page numbers, my lord. I have rectified my brief since then.
Yes.
My lord, will kindly take clause 64.1, my lord, demand for arbitration.
GCC.
Yes, my lord, GCC, my lord. I'm so grateful, my lord.
Yes.
My lord, 249, my lord, it starts demand for arbitration. My lord, if your lordship will just turn over 250, my lord. In the event any dispute or difference between the parties hereto as to the construction or operation of this contract or the respective rights, liabilities of the parties in any manner in question, in any matter in question, dispute or difference on any account as to the withholding by the railway of any certificate to which the contractor may claim to be entitled to, or if the railway fails to make a decision within 120 days, then in any such case, but except in any of the accepted matters referred to in clause 63.1 of these conditions, the contractor, after 120 days, but within 180 days of his presenting his final claim on the disputed matters, shall demand in writing that the dispute or difference be referred to arbitration. My lord, then, my lord, the demand for arbitration shall specify the matters which are in question or subject of the dispute and difference, as also the amount of claim item wise. Only such dispute or difference in respect of which the demand has been made, together with counter claims or set off given by the railway, shall be referred to arbitration, and other matters shall not be included in the reference. The parties may waive off applicability of section 12.5 of the arbitration and conciliation.
Don't place this
Very
place
well.
clauses which are not relevant. Yes.
Now, my lord, only one clause, my lord, the accepted matter, because here it's saying talking about accepted matter. If your lordship will
No,
take,
first you have to show that the GCC applies.
yes, my lord, that your lordship will
Then all your other arguments will come.
very well, my lord. On this point, my lord, they have relied on the GCC for termination, my lord. Their termination letter, where they have terminated my contract, is also under clause 62 of the GCC.
Yes.
And also, my lord, on my lord, subject to my lord, what has fallen from your lordship, if your lordship will take page 155, my lord, of volume 1, my lord, volume 2, my lord. I'm sorry, my lord, 165, my lord.
Yes.
My lord, will kindly see applicability. These conditions of contract shall be applicable for all tenders and contracts of railway execution works as defined in GFR 2017. And my lord, also, if your lordship will once, my lord, take page 155, my lord.
Yes.
My lord, this is a notification, my lord, by the Ministry of Railways, my lord. It says Indian Railway Standard General Conditions of Contract, July 2020. My lord, I am not placing the entire, my lord, only your lordship will take clause 5. The GCC July 2020 shall be applicable to work contracts on Indian Railways with prospective effect.
Yes.
Now, my lord, they have also relied on, my lord, the GCC, my lord, clauses of the GCC, my lord, to terminate my contract.
Yes, next.
Now, with my lord's leave, my lord, can I place the accepted matters, my lord, because to show your lordship that this is not a
dispute.
My lord, the dispute is, my lord, what had happened is, my lord, I had commissioned the work at that site. My lord, during the pendency, my lord, the contract was initially for a period of 1 year.
Yes.
My lord, during the pendency of the contract, my lord, they have admitted, they have issued a letter under 17A of the GCC, my lord, admitting that there was latches, my lord, on part, not of the contractor, because 17A says, my lord, delay or latches for which the contract might be extended for reasons not attributable to the contractor, which is me. My lord, they give me an extension. My lord, the extension was for a particular period. During that period, my lord, during that period of extension, my lord, they terminated my contract by a letter. My lord, after that, my lord, they have forfeited my security deposit, which is under clause 16.1 of the GCC, and my performance guarantee under 16.4 of the GCC, and there are certain unbilled amounts. If your lordship will see my claim, my lord, which I have annexed at page 287.
They have forfeited your security deposit and what?
My lord, my performance guarantee under 16.4
Yes.
of the general conditions of contract.
Very well. What is the page you were wanted to show?
My lord, 287 is my claim, my lord. This is what would have to be adjudicated, my lord, that your lordship will find at volume 2.
Yes.
My lord, will kindly see, my lord, I have tabulated claim wise. My lord, claim 1 is work done and unbilled amount.
Yes.
My lord, claim 2 is forfeited PG amount. This is my lord, performance guarantee, which is under clause 16.4 of the GCC.
And what is this a part of?
My lord, the forfeited, my lord, performance guarantee amount is in.
What is 287 a part of?
My lord, 287, my lord, is, my lord, they had submitted a letter, my lord, under the arbitration agreement. My lord, I am supposed to give them, there's a format, my lord, on which, my lord, I have to give them my claim.
Yes.
My lord, this is a format, my lord, which they had supplied, my lord. This is how I have, my lord, tabulated my claim. Now, my lord, claim 3 is forfeited, my lord, security deposit amount, and claim 4, my lord, losses and damages. So, my lord, these are the claims upon which, my lord, I seek reference.
So what is the total claim?
My lord,
Now,
1 crore 20 lakhs, my lord. My lord, this I have also indicated in my letter, my lord, for reference to arbitration and, my lord, for settlement of claim.
anything else?
Yes, my lord. So what had happened is, my lord, when they had terminated during that 17A, my lord, when that 17A was, my lord, applicable, my lord, they terminated my contract. My lord, after that, my lord, I had written to them saying that you please settle my claims, which they had not. Now, my termination was under 62. Now, my learned friend might take a point that 62 is an
Accepted matters.
accepted matter. But, my lord, my dispute, which is, my lord, before the arbitrator or the adjudicating authority, is not on 62, my lord. I'm not asking for specific performance of the contract.
Yes.
I am asking for, my lord, my forfeited SD, my lord, that is my security deposit, and my forfeited, my lord, performance guarantee, which is, my lord, if your
Yes,
lordship,
please leave, don't cough in the court. Yes. Yes.
my lord, that is, my lord, clause 16.4 and 16.1. My lord, 16.1 and 16.4 are not, my lord, accepted matters. And, my lord, the arbitrator, my lord, cannot, my lord, restrict, my lord, his scope, my lord, to 62. My lord, he has to meander into 16.1 and 16.4, my lord, which are not accepted matters. And that is, my lord, for the tribunal, my lord. My submission is, my lord, this would not be construed as dead wood, my lord. So this would be, my lord.
Yes, how do you propose to
I'm good.
object?
My lord, as the representation is concerned, my lord, there is no explanation, so I'll leave it to your lordship.
Representation?
They sent a representation dated 20th December 2021, which I was supposed to consider and give a.
I'm not aware. What is this?
There's a representation which was made for.
Which page?
My lord, it's pleaded on page 11 and the representation is on.
Yes, so it's annexure I. Where is annexure I? If you're placing something, you should know where it is. You're mentioning a representation and you don't know where it is in the papers.
My lord, I will just, it's my lord, page 272. I was supposed to consider this and within 3 months, and this has not been done.
And this is representation to what?
My lord, this is regarding the settlement of claim and dispute.
Yes, what is the representation for?
No, this is a representation, my lord, under the arbitration agreement, my lord. First, I wrote them a letter, which, my lord, is contemplated in the arbitration agreement for settlement of my claim.
Yes.
My lord, 120 days, my lord, they are supposed to settle the claim under the agreement. If they don't, then, my lord, I will, my lord, seek for reference to arbitration.
That's under clause 64.
Yes, my lord.
Yes.
My lord, that I have, my lord, that is annexed at page 276, my lord, my letter invoking the arbitration agreement.
And 120 days has gone?
Yes,
from
my lord,
the- From the representation?
Yes, my lord. After 120 days, my lord, I have sought for arbitration, my lord.
My lord, my only instruction is this will be pertaining to GC 2014. Because this contract was in 2014.
Contract is of 2018.
No, miss, my lord, 2014 GC prevailed at that time.
Yes. The dispute between the parties arises out of an agreement which forms part of the tender document. And an E-tender notice of 5th July 2017 Stop. The petitioner was a successful bidder and entered into a contract with the respondent railway on 2nd April 2018. Where do I get that date from?
Lord, your lordship will find that at page 22, volume 1.
2nd April 2018. Stop. The petitioner was to respondent Southeastern Railway. The petitioner was to supply, erect, test and commission. What is PSI? OHE and PSI? What is all
Lord,
this?
OAG is overhead electrification.
And
My lord, of a freight terminal, and my lord, PSI, my lord, I'll just take instruction.
and commission overhead electrification in connection with the freight terminal capitals at Shankrail, SANKRAIL. Stop. The contract value was approximately of an amount of rupees 3.53 crores. Stop. The contract agreement provides for an arbitration clause. The contract was made subject to the general conditions of contract, which in turn provides for a demand for arbitration, quotation marks, under clause 64.1, within brackets, of the GCC. Stop. Clause 64.1 provides for a mechanism by which the railway is to take a decision within 120 days of any claim made by a contractor, except the accepted matters, quotation marks, under clause 63.1 of the GCC. Stop. The regulations for tenders and contracts. Now, clause 1.0 of the regulations for tenders and contracts, which forms part of the Indian Railways standard general conditions of contract, makes it clear that the GCC would apply to all tenders and contracts of railways, including the present contract. Stop. Notification dated 16th July 2020 of the Ministry of Railways, also makes it clear that the GCC July 2020 shall be applicable to works contracts on Indian Railways with prospective effect. Stop. Next, the petitioner, through learned counsel, urges that the respondent railway terminated the contract within while extending the term of the contract, and also appropriated the security deposit as well as the performance bank guarantee furnished by the petitioner. Stop. The petitioner made a claim on the respondent railways
$272 million.
on 20th December 2021 and also sent a representation, made a claim on 20th December 2021, which was also in the form of representation. Stop. Where is the 21 notice?
That's at page 276, my lord. The date is 22nd August 2022.
The petitioner also invoked the arbitration clause in the arbitration clause in clause 64.1 of the GCC by way of a notice issued under section 21 of the 1996 Act to the respondent on 22nd August 2022. Stop. The petitioner now claims an amount of approximately rupees 1.20 crores. The petitioner's claim is part of a letter dated 16th November 2022. Stop. Next, learned counsel appearing for the respondent, Southeastern Railway, submits that places the. Have you replied to the representation? No. Refers to the representation made by the petitioner on 20th December 2021 and submits that the only and argues that the only instruction is that the GCC of 2014 be followed, since that GCC was prevailing at the time of the contract of 2nd April 2018. Stop. Next, upon hearing the submissions made on behalf of the parties, there is no doubt that the parties have an existing dispute between them. Stop. The petitioner's performance bank guarantee and security deposit have been forfeited, and the petitioner's claims also arise out of unpaid invoices. Is that correct or not? Unpaid invoices. Stop. Whether the GCC of 2020 or 2014 will be followed will be a matter which will be decided by the arbitrator. Stop. This would also form part of the disputes between the parties. Stop. Next. Next, the ACI paragraph level. The presence of the arbitration clause, the presence of the arbitration agreement is also undisputed. Stop. The presence, the arbitration agreement is also undisputed. Stop. Next. AP 507 of 2023 is accordingly, at a line the more than 120 days have passed since the representation sent by the petitioner on 20th December 2021, and there can hence be no further impediment for the court to appoint an arbitrator in terms of the arbitration agreement, in terms of the arbitration clause. Stop. AP 506 of 2023 is accordingly allowed and disposed of by appointing blank to act as the arbitrator, subject to the learned arbitrator communicating his consent in the prescribed format to the registrar original side of this court within 3 weeks from date. Stop. The advocate on record of the petitioner shall communicate this order on the arbitrator within 7th September 2023, along with the requisite details of the contact person of the petitioner.
Lord, PSI, my lord, would be, my lord, power supply installation, my lord.
ওই যেখানে একটা overhead electrical কি একটা বললাম না OHE
Overhead.
electrical overhead electrical একটা and power supply installation হবে একটা জায়গায় বললাম
My lord,
and power supply installation.
only the forfeiture of the security deposit and the money is done as per the agreement because the unused material wasn't returned.
একটা লাইন লিখে রাখো যেখানে the respondent is argument বললাম. Council submits that the respondent forfeited the security deposit and the performance bank guarantee in accordance with the terms of the contract.
Grateful.
Next.
I'm grateful, my lord.
Item number 3, Messrs. Vision Geoinformatics Private Limited.
I appear on behalf of the petitioner. Lord, I beg pardon for the inconvenience caused by me, Lord. The petitioner,
What inconvenience?
but I coughed, that's why probably you lost.
Inconvenience not to the court, but
Yes, definitely.
your colleagues
Absolutely.
waiting in the court.
Absolutely. But the facts of the case is that
Where's your respondent?
I have served, nobody is appearing. The same
You
respondent
have to
also
first
didn't
show
appear.
the affidavit of service. 11th August,
Yes.
Hyderabad.
No, this is Kolkata address. Respondent-
Telangana, Hyderabad, Telangana.
Respondent number 1 is actually office is shifted from Hyderabad to Kolkata and served in Kolkata address. He received this. A track report shows that they have received. In another matter also, they did not appear.
Yes, what is the dispute?
There is an autonomous body called Maharashtra Remote Sensing Application Center, which is under
What do they sense?
they were deployed at the work. They have undertaken a project called MOUSHUMI. Your that you will find that is at page
Can't
1.
understand, what is the contract
Yes,
about?
that is the contract I'm just telling. But their contract is for ortho rectification, technically known as ortho rectification of high resolution satellite data. The contractor, the petitioner has been given subcontracted by the principal contractor, that is the respondent number 1. Now the contract is at page 51.
No, is the petitioner the contractor or the
Subcontractor. Subcontractor given by the respondent being the contractor, principal contractor, contract taken from the Maharashtra government, that autonomous body.
Yes.
Now, the agreement starts at page 51 and the scope of the contract, scope of the work is as page 52. Technically, it is called ortho rectification of high resolution satellite data.
Where are you reading from?
Page 52.
Page 52 is an entire page. Where are you reading from?
I'm reading from the page 52 scope of the work. Page
It may be highlighted in your copy, not in mine.
No, yes. Page 51, the agreement starts, the agreement dated 1st of June 2018.
Yes.
And the scope of work is page 52.
Yes.
Top scope of the work. If the issue kindly finds it.
Yes.
Scope of the work involves ortho rectification of high resolution satellite data for remote sensing applications. Besides ortho rectification of high resolution satellite data, less than 1 centimeter, 1 meter resolution.
Just tell me what the scope is.
That is the scope for creation of wave, that is called digital, the technical term is digital elevation model, creation of digital elevation model and the ortho rectification of satellite data. Now, this scope of work, we carried out the works and the arbitration clause is at page 60.
Show me the first page of the contract.
Contract first page is page 51. Contract is made on 1st of June 2018 between on one hand Statelites and on the other hand Vision, the petitioner. Whereas the client has requested a firm to provide certain services for AT, it is called aerial triangulation, and DEM editing, it is called digital elevation model, and ortho generation.
Where is the arbitration clause?
Arbitration page 60. I must be candid. There are 2 agreements. I have filed the petition concerning the 2 agreements, but I am supposed not to praise for that other agreement. I got
I don't understand.
There are two agreements. The scope
Yes.
of work is
It's a
different.
composite reference.
Composite reference, but the scope of work is different. So I cannot press for that, the other agreement. I am only pressing for this agreement only. If you
So what is the point of being candid if you are pressing for only one?
only one. So I
Then-
stated in the petition, that's why I did not, I should point out before leadership. Now, so agreement, arbitration clause is at page 60. Disputes, may I read? Disputes shall
I
be,
will not pass any order unless I hear the other side.
as your
All right?
lordship.
Yes, yes. Disputes?
Disputes shall be settled by arbitration in accordance with the following provisions.
Yes.
That in default of the compliance performance of the terms and conditions created by this covenant by any of the parties or any of the parties contravenes the terms and conditions created by this covenant, in that event, any of the aggrieved party reserve the right to legal action for breach of contract, breach of trust, or for the past performance of the specific reliefs in a competent court of law for the redress and efficacious remedies. Jurisdiction for the redressal and remedies shall be in Kolkata High
Very
Court.
well, yes, yes. What is the dispute?
Dispute is, I have worked for this ortho rectification high resolution data, and the different work orders were issued right from page 61. The work orders, page 61 is running to up to page 73 for this work. Page 61, if your leadership kindly
Just
comes
tell
to
me the contract period.
contract period is 90 days. You have to do the work. Now, there were some delays on our part, and the delays are also
No,
attributable
no,
to them.
unpaid bills for which period?
The contract was from 1st of June 2018, and it has to be completed with the September 2018. 9 months, 90 days, yes, 90 days, September 2018. Now I did the work and raised the invoices. The work orders starting from page 61, different work orders of different value. Total value of the contract is 2.2 crore 28,89,503. There is a chart, page 110. The chart shows the calculation.
2.2 crore or 22 crore?
2.28 to 2 crore 28,89,000.
Yes.
228,89,503.
Yes.
And the due amount is, as per our claim, 66,66,84,755. And the work completion certificate is also there, page 111, by the principal autonomous body, principal company, that is at page 111. Then I raised the invoices starting from page 75 onwards.
You just said work orders from 61 to 73.
Yes, then 61 to 73 work
So
orders.
different work orders.
No, different, yes, different work orders.
Each containing an arbitration?
Yes. No, only one agreement, under one agreement, different work orders.
No, do the work orders contain arbitration clauses?
Work orders, only work orders, this that does not contain agreement, principal agreement is there, agreement, under that agreement, the work orders.
Show me a work order.
Yes,
please.
ma'am. The first work order is page 61. That the scope of work I have already pointed out, area triangulation, LTF editing, DM generation.
Very well, yes. Next
Then-
point.
Then page 75 onwards, my invoices for all these projects. First invoice just I referred to, page 75, invoice for aerial triangulation and other things. Then the invoices goes on.
Give me the time frame, please.
Yes. Time frame, they were supposed to pay as per terms of the contract. Payment terms is there, that they were supposed to pay within phase by phase. They were supposed to pay within 20% mobilization advance and others. Then I raised the claim. After the invoices were raised, they did not pay the entire money. Then I raised
Tell
the
me
claim.
the period during which you raised the invoices.
The invoices, I'm telling you, the page 75, 4th of October 2018, the first invoice raised. 4th of October 2018. 4th of October 2018. That is at page 75. And the last invoice is for 5th of January 2021, which is at page 109.
Yes.
Then they did not pay. They also, I sent several mails, just one or two mails I just referred to, page 286. No, page, I'm sorry, page, yes, 286. Page 286 is the mail of the second volume, where I demand this from this particular project. And then I send the notice, page 287, for invoking arbitration clause. Page 286. January 4, 2022 is a mail sent to them as you are, as you know.
Don't place the,
Yes,
just give me the
This is-
time frame. Give me a broad idea, please.
The invoices were raised from 4th of October 2018 to 5th of January 2021. They were supposed to pay immediately after the raising of the invoices. They did not make the payment. Thereafter, then I sent these reminders by mails, page 286, one of such mails. And then I sent the arbitration notice for arbitration clause. Page 287, it starts. And they received the notice, they reply.
So that's the notice under?
That's the notice under 21.
Say that, please.
And then the reply they have given, which is at page 294. They say the delay is caused by you and the claim is also not tenable. That's their stand. They do not accept the arbitration clause. They are silent about the arbitration clause. Page 286, my arbitration clause, they notice, and then the receipt, which is acknowledged at page 292, and they reply
Page
at page
286,
the 286 is the notice, 287, the notice starts, and then the arbitration clause I invoked, which is at page 291. And then they reply at page 294. And in respect to the same party, in respect to another.
and
party,
what did they say in the reply?
They reply, they said that delay, they give a chart that we have caused the delay in completing the work. So they are not liable to pay that. And this quantification is also they dispute.
What is the claim now?
Now claim is 66,84,755.
On what basis?
This is the chart I've given, page 110, before the issue penny funds at page volume 1. This is JSCOM, I leave, this is the another
No,
project.
that's all right, but what is this a part of?
This is a part of our claim that the page page 110, this was sent to them. This is the part of the project to project number 2 and 3. This comes about this. The payment received I have made, the payment due I have given, and I have calculated the amount that comes about 66 lakhs due. Total value is 2 crore 28 lakhs. Project wise is given, it's project number 2 and 3, it covers this. And in respect to the same party, not in respect to another agreement, your ladyship has passed an order earlier. They also did not appear on that, in that case, which is at page 299.
The affidavit of service shows that the respondent was served on 11th August 2023. Stop. The respondent, however, is not represented. Stop. Next. The dispute between the parties, the petitioner seeks appointment of an arbitrator through the present application filed under section 11 of the 1996 Act. Stop. Next, the dispute between the parties arises out of an agreement, capital A, for ortho-rectification of high-resolution satellite data between the respondent and one Vision Geoinformatics. Stop. The respondent number 1, the respondent is the contractor, comma. Vision Geo is the principal, PAL, principal, capital P, and the petitioner before the court is a subcontractor. Sub-contractor.
Vision is the petitioner.
Sorry?
Vision Inj is the petitioner. Principal is Maharashtra State Remote
Yes,
Sensing
yes.
Application.
The respondent is the contractor, comma. The petitioner / Vision Geo, duto alada kotha, page 51 page. Vision Geo is the subcontractor, and Maharashtra what?
Maharashtra Remote Sensing Application Center, page 111. Your Lordship.
And the Maharashtra Remote
Sensing
Sensing
Application
Application
Center.
Center is the principal. Stop. The principal's name would appear from a work completion certificate issued by Now, the name of Maharashtra Remote Sensing Application Center would appear from a work completion certificate issued by the said entity. Stop. Next, the straightforward facts, the straightforward facts in the present application are that the petitioner are that the respondent issued work orders, several work orders to the petitioner for completion of the work for a total contract price of approximately rupees 2.28 crores. Stop. The petitioner alleges that the petitioner completed the work to the satisfaction of the respondent contractor and raised invoices from 4th October 2018 - 5th January 2021. Stop. The work orders and the invoices are part of records. Stop. Next. The respondent, now on the respondent's failure, apostrophe S, on the respondent's failure to make any payment in terms of the invoices raised, comma, the petitioner issued a letter of demand on 4th January 2022, page 286.
Yes, 286.
On 4th January 2022, following it up by a notice, with a notice invoking the arbitration clause under section 21 of the 1996 Act on 5th November 2022. Stop. The arbitration clause is part of the contract executed between the parties. Stop. The respondent replied to the notice on
2nd of June 2023.
2nd June 2020, page 294.
Yes.
2nd June 2023, attributing the delay in the attributing the alleged delay in the completion of the work on the petitioner. Stop. The respondent did not have anything to say on the arbitration clause. Is that correct or not?
Yes.
Did not have anything to say on the arbitration clause. Stop. Next. The material placed before the court leaves little doubt that there is an arbitration agreement between the parties and an existing dispute in the form of the petitioner's unpaid bills for the work done. Stop. The dispute is directly relatable to the arbitration agreement. Stop. The respondent's reply does not deny or dispute the arbitration clause, the arbitration agreement. Stop. Next. This is a fit case, therefore, when the court can intervene under section 11 within brackets 6 within brackets small a of the 1996 Act for appointment of an arbitrator to resolve disputes and differences between the parties. Stop. Next. AP 532 of 2023 is accordingly allowed and disposed of by appointing blank to act as the arbitrator, subject to the learned arbitrator communicating his/her consent in the prescribed format to the registrar original side of this court within 3 weeks from date. Stop. The advocate and record of the petitioner will communicate this order on the arbitrator by 7th September 2023, along with all the requisite details of the petitioner's contact person.
Keeps your best.
Next.
Item number 4, Prabhu Darshan Developers Private Limited.
This is my section 11 application.
My lord, I am appearing for the respondent.
I can't hear you.
This is my section 11 application.
Yes.
My lord, I am appearing for the respondent. Just a small indulgence, my lord, I have received the brief this
Can't you
morning.
know, don't you know how to use a microphone? I'm telling you, I can't hear you.
I have received the brief this morning, my lord. Kindly gives me a day's
Tomorrow-
time so that
tomorrow.
I can.
Tomorrow. List this matter tomorrow on the prayer for adjournment made on behalf of the respondent.
Five, Hitesh Agarwal.
And I'm appearing for the respondent in this matter.
Waiting for the petitioner, my lord.
Yes, how much you have to secure?
My lord, there is a talks of settlements going on.
Settlement?
Yes, my lord.
But there are talks of settlement going on in this matter, my lord.
Yes, so
I
how
was
much-
humbly praying, my lord, if this matter can be posted after 2 weeks.
Yes, learned counsel with the parties submit that the parties are exploring a settlement. Stop list this matter after 2 weeks as prayed for.
Great for-
Next.
Item number 6, Ranjana Bhattacharya.
I for the plaintiff, my lord.
Plaintiff.
The petitioner, my lord. Lord, I will be, my lord, seeking some time, my lord. My lord, the advocate and record, my lord, was there in the, my lord, the court. My lord,
Are you the counsel?
my lord.
Then why are you seeking time?
Well, I was instructed by the advocate and record. My lord, I shall proceed, my lord. I have,
It's a 34,
my lord, 29A. 29A, my lord.
29A. Where is your other side?
But we have served, my lord. My lord, the affidavit service, my lord, is showing, my lord, it has, my lord,
Are we mandate subsists or gone?
my lord, 31st of, my lord, August will, my lord, expire, my lord.
Will expire.
Expire.
31st August of 2024.
2023, my lord, it has expired, my lord.
Why are you saying will expire?
I am holding, my lord, senior's brief, my lord. I am, my lord.
If you're not ready, take time. Tomorrow?
Well, I can, my lord, today, I can, my lord.
You know, you're not, you don't look like it. So to come back tomorrow.
Okay.
Yes, list this matter tomorrow as prayed for.
Now done.
Next.
Item number 7, Union of India.
My lord,
I am
appealing
for the respondent award holder.
I'm going to file up my reply, my lord. Because
Sorry,
that
I
was-
can't understand what you're saying.
My lord, the reply to be filed up, my lord.
Filed up?
I mean, to be filed up means I'll be filing
Be
the
filed,
reply, huh?
please.
Yes, my lord. There is an opposition in regard to GA2 and as well as a reply to the opposition of GA2 and
What is GA2?
GA is that is in regard to, my lord, the award was been passed in pandemic, my lord, and even the 34 application was filed during the pandemic period, my lord. There was some delay in regard to that because the file was,
It's your 34.
yes, ma, it's my
So
turn.
it's beyond the 120 days.
That was beyond 120 days. Thereafter, the stay application was also been admitted, my lord. The stay was granted. We had submitted
I
25.
can't understand. If your 34 is beyond time, how can a stay be
My lord,
granted?
during the pandemic period, it was been done, my lord.
You have to explain.
I
how
have
to-
explained, my lord. In GA2, I have explained why there was delay, my lord.
No, no, you're taking advantage of Supreme Court orders.
No, my lord, I'm not going to take that one, my lord. I myself have been operated at the period of time. Even my father was taken to Apollo Chennai. At that period, the file was.
Mr. Agarwal, I'm sorry to say,
Yes, my lord.
you can take advantage of the Supreme Court orders. Otherwise, facts will not help you. It can't. That's the law.
My lord, the file that was being the 34 application was there in the court itself. I had affirmed the before that is within 90 days, my lord. Thereafter, what has happened? I had to leave for Chennai. The file was in the filing department because there was some mistake in the notice of motion, my lord.
Has the application been affirmed within 120 days or not?
That was affirmed before 90 days, my lord.
Then why is all this GA2 and all this? Why?
My lord, that was not but filed because there was typographical mistake in the spelling of the Honorable Justice, my lord. That was the reason they did not give me.
Are you aware of this point or not?
Yes, sir.
You are.
But
34
I
within
have-
time or not?
Actually, award dated 24th September 20, received on 28 September 20, petitioner affirm on January 21, filed on 1st March 21. If they rely upon Supreme Court decision, I have no say. But if they rely upon the section 5, possibly section 5 does not allow.
Yes, Mr.
applicable.
Agarwal, please don't waste the court's time.
Yes,
How do you come within 34.3? I read with the proviso.
My lord, I had affirmed, that is, my lord, the award was
Set of the
passed
policy.
on 24th of September 2020, my lord. I had affirmed the application on 4th of January 2021, my lord. So that is 24th September 2020, 4th of January 2021, my lord, if it's been
So you're
taken.
within 120 days.
Yes, my lord.
Very well. So then what is the GA2 for?
That is explanation why the thing has happened. That is after coming, there was a typographical mistake into the notice of
Both
motion.
of you
That is the reason.
are on the same boat. Yes. So you want to argue a 34?
Yes, my lord.
Are you going to take a point of maintainability or not?
I have taken it, but I have not. I know the Supreme Court decision with me also. I know.
Supreme Court decision is till 28th February 2022.
Yes.
So you're falling within that.
Yes, my lord.
That is in 21, I've done it, in January 21.
Very well. Yes.
My lord,
So now what am I hearing? The 34?
should I start, my lord?
I'm asking
Or
you.
34, my lord. My lord,
Yes, tell me the law, please. So what is GA2 and GA1? What are those? I'm disposing
GA1
them.
was regarding the stay, my lord, the operation of the award, my lord. Stay
So
of
you-
the operation
the-
of award.
The award is stayed.
Yes, my lord.
You have paid the security?
Yes, my lord. In
Part. Instead of 40 lakhs, they paid it 25.
no, my lord, the stay, the 25 lakhs were been asked me for furnishing the cash.
Doesn't matter. Show me the awarded amount, please. I will modify that award.
38 lakhs, my lord.
Show me the awarded amount. How can you pay 50%? Show
My
me the
lord,
awarded amount.
that award, I can give out the order that was been passed on.
Doesn't matter. I will change that order. You will have to put in the entire awarded amount. Yes.
Not kindly come to page 14, inner page, last annexure of the petition.
Page
38 lakh,
14.
inner page. Awarded portion.
What are you saying? Inner page, inner page.
My lord,
what
after page number 93, my lord, of application 34, my lord, the award starts with, and the summary of the total thing comes up at page number, the internal page 12 of the award. After page number 93, my lord.
What is the awarded amount? Show me.
The amount is at the page number 14 total, 38 lakhs 968.
Where are you finding that?
My lord, in page number 14 of the internal page of the award, after page number 93 of my application, that is for section 34, my lord. The second last page of the application, my lord.
38 lakhs.
38 lakhs 968.
And how much have you secured?
My lord, 25 lakhs have been asked to deposit. I have furnished.
On what basis?
My lord, the award that the Honorable Justice Ravi Kishan Kapoor has asked me for 25 lakhs. I have deposited.
Show me the order, please. I'm changing that order. Show me the order.
Yes, my lord.
Page.
You are the railways.
Yes, my lord. We are the
Furnish
railway.
the balance. I'm giving you time. Furnish the balance. The 38, there is no basis why I should be given the benefit of the unpaid amount. How much time do you want? Put in the whole amount, the balance.
My lord, we are going to deposit cash only because we don't have the
Cash,
bank guarantee
do it,
system.
do it.
But that the time should be given because the accounts department has to be approved.
No,
by the
is
finance
the
department.
award stayed?
Yes. The award has been stayed.
Yes, yes. So put in the balance amount, please. 38, you have given 25.
Yes, my lord. It comes to 13 lakhs more.
13 lakhs. How much time do you want?
At least, my lord, 3 weeks, my lord.
3 weeks,
Yes, my lord.
2 weeks, 13 lakhs.
My lord, may I say one thing?
Yes.
Can I withdraw the part of the sum?
Withdraw. You don't even know what the matter is about. You want to withdraw. You
Ah,
can't even take a
yeah.
point of objection. Absolutely not. Get ready in the matter. Argue.
My lord, if it's a prayer altogether, my lord, 3 weeks, because it's going to take out from the accounts to finance, I'm going to furnish out within 3 weeks.
13
my lord.
lakhs, yes. The documents placed before the court show the impugned award dated 24th September 2020 shows that the awarded amount in favor of the respondent was rupees 38 lakhs.
Plus interest.
38 lakhs being the principal amount. Stop. The petitioner has paid, the petitioner award debtor has paid rupees 25 lakhs as security for stay of the award. Stop. The award has remained stayed from 14th December 2021. Stop. The Section 34 application has come before this court for the first time today for hearing. Stop. Next. Before this court proceeds any further to consider the application for setting aside of the award, the petitioner must put in the balance rupees 13 lakhs with the registrar original side of this court. Stop. The petitioner, learned counsel appearing for the petitioner seeks time to do so. Stop. Next. List this matter on 21st September 2023. Stop. The petitioner shall put in the balance rupees 13 lakhs with the register original side within the returnable date.
My lord, it could be extended to another 5 days, my lord, because
5 days.
yeah,
Why?
my lord, I have to get out, all the departments have to be done out, my lord.
Your
because the
rate
cash,
is 13
my lord,
lakhs.
they don't have the BG, my lord. They have all
What
the cash
BG?
bank guarantee, my lord.
Put in cash. Put in by way of cash.
That cash.
You're sitting on the award. You have
My lord,
stayed the
my
award
lord,
from from 2021.
Yes.
We are in 2023.
Yes.
I am hearing the Section 34 for the first time. What happens to the award holder? 13 lakhs in 2 weeks. Next. Call on the next matter.
My lord, I never objected to that, my lord. 25 lakhs was said, I said,
You should have told the court that you're willing to put in the entire amount. Next. Next.
8, Balasur alloys.
Your Lordship, this is my application. My Lord, this is my application under Section 48, seeking declaration with regards to objecting the enforcement of a foreign award. Your
Last time
Lordship.
you had said that you don't have any instructions.
Yes, Your Lordship, I
What
have got
happened?
instructions, my Lord. What has happened is this application, there is no formal application under Section 47 for the enforcement of the award, Your Lordship. This application has been filed in an apprehension because, my Lord, a post-award Section 9 application has been filed by the respondent in the garb of enforcement, my Lord. And order was passed. Thereafter, my lord, it was appealed, and your lordship, a special leave petition has been preferred before the Honorable Supreme Court of India, wherein the respondent have made a submission which is recorded. I'm carrying that order, your lordship, that they have said that they are
Supreme
going to
Court order dated? Must be, can't be a recent order.
28th April 2023, your lordship.
Yes.
In that order, my lord, they have already stated that they are going to file an application under Section 47, my lord. So already 2 weeks time has passed within that.
So then why do you want to file this 48 as a cautionary measure?
Your lordship, it was a cautionary measure. What I'm seeking today is either, your lordship, this matter is adjourned unless they formally file the application under 47, or if your lordship is of the view that this cannot be kept pending, my lord, then I'll seek liberty to withdraw this application with liberty to file a fresh, my lord. As and when the
Withdraw.
section-
You can't file an application on the assumption or on the apprehension that they will file a 47.
Yes, your lordship, in that even may I withdraw
And
with
keep
liberty to
it
file
pending.
afresh.
Yes. It is clear from the submissions made on behalf of the petitioner that the present application under Section 48 of the 1996 Act has been filed on the basis of an apprehension that the award holder will file an application under Section 47 of the Act. Stop. The application has been filed on 11th July 2023 and kept pending in the list Whereas you're for the respondent.
Yes,
What is happening?
Your Lordship, I have not been served with this application.
You don't have any other submissions to make?
No, and no enforcement has been filed yet, so this application cannot stand.
Yes, ki bola? And has been kept pending in the list for essentially for the respondent to come up with an application under section 47 of the Act. Stop. Next. You're the advocate on record.
No, Your Lordship, I'm the counsel.
Sorry. Learned counsel appearing for the respondent submits that the respondent has not filed, is yet to file the application, an application for enforcement of the award. Stop. Next. This court is hence of the view that there is no that the present application should be dismissed as withdrawn, since the application is has been used as a buffer, with the petitioner not having any real intention to move the application. Stop. As a buffer to enforcement of the award, since the petitioner has no real intention to move the application. Stop. Next, AP 465/2023 is accordingly dismissed as withdrawn.
Your Lordship, I'm seeking liberty to file afresh, my lord, as and when the application under section 47
Liberty to
is
file afresh. Next.
grateful, your Lordship.
May it please. Your
9,
Ladyship.
Somabrata Mondal.
May it please, Your Ladyship. My lord, I wish to file affidavits, my lord, here.
What affidavits?
There's the application for amendment, but my lord, there are certain allegations which have been made on affidavit which I need to deal with, my lord. For that purpose, a short affidavit, my lord, I file an affidavit for that.
Why do you need to file an affidavit?
My lord, there are allegations which have been made personally against.
What allegations?
My lord, that they tried to make service and we denied service. Which is
You're
not a
appearing
fact,
for?
my lord. But I'm
It's not-
appearing for respond numbers 3 and 4.
That's Fox and Mundal.
Yes, my lord.
Yes. Who are the others then?
My lord, respond number 1 is the registrar trademarks. My lord, your lordship will recall, my lord, here what has happened is, my lord, the erstwhile respond number 2 had died, my lord. So, my lord, they had taken out an application for amendment. The amendment which they caused was only in the cause title, but in the body, my lord, the amendment was not carried out. So a service copy which was made over to us included service copy of a writ petition where in the body also amendments were made. But my lord, when we picked up, we took out applied and obtained a certified copy of the writ petition, which was amended, my lord. That, my lord, in the body, the amendment has not been carried out.
This is
So now they
assigned.
filed an application.
It's an assigned matter.
So now, my lord, they filed an application for the purpose of carrying out the amendment in the body of the writ petition also. And they have made allegations that they attempted service and we denied service, including allegations against the department.
Sir Mukherjee, if you want to file an application by Friday, please.
Affidavit, my lord.
Affidavit.
Affidavit.
Affidavit by Friday.
My lord, will kindly keep it Monday.
No,
not Friday.
no. If you want to file affidavit for all these personal allegations by Friday.
Your
Yes,
Ladyship, may it please, your Ladyship. In the meantime, let the amendment be carried out. How can that be done?
What amendment
I'm
we can-
opposing, my lord. Opposing to the amendments? I'm opposing to I'll file an affidavit dealing with the statements, my lord, which have been made.
Just only one
My lord, they
paragraph
can't
because
keep
it was served.
Filing an
in the
application
court.
for amendment over and over
Ladyship-
again for the same thing.
Your Ladyship,
Well,
I
I'll take
believe
my
what they're
points, my
relying
lord.
on, what I've submitted before this honorable court on the previous date.
My lord, I'll file an
It's
affidavit
nothing-
and the prayer will be allowed. That is also not possible, my lord.
It's just replacing name of the respondent number 2 as amended in the cost title. I
Very
don't think
Mr.
that
Mukherjee,
extent there
Mr.
would be
Mukherjee, by Wednesday, I'm keeping this matter on Friday. All right.
My lord, Friday, my lord, and Monday. My lord, Friday I'll file it, my lord.
Mr. Mukherjee, I shouldn't even allow you to file any affidavit. Yes. And I'm not allowing affidavits in any matters unless counsel show cause
My lord,
why
here,
they
since-
will be
since
allowed.
Personal
affidavits.
allegation was made against me. That's why I wanted to do it.
By tomorrow then, by tomorrow. Yes, learned counsel appearing for the respondents, respondent numbers
2 and 3.
2 and 3.
Now, Malad, it's 3 and 4, still 3 and 4.
Respondent numbers 3 and 4 wishes to file an affidavit to deal with the personal allegations made in the application for amendment. Stop. Next, affidavit in opposition by you, by 6th. By 6th, list this matter on 8th September 2023. Reply, if any, before within the returnable date.
Much obliged, Your Ladyship.
Next.
Item number 10, BBM Enterprise.
Mr. Chidambaram is waiting for which matter?
That IQ City matter, my lord, the other side is to reply, and I will only listen
IQ
to their reply.
Mr. Chidambaram, that will be the appellate side matter. Yes, I will call it on shortly.
Whenever.
I'm seeking for an adjournment, Lordship, of the
Which matter is this?
serial number 10 of the original side, Lordship. Mr. Sen is leading me in the matter. He had to leave on an urgent personal need.
Yes,
Up tomorrow.
list this matter on 8th September 2023. Stop. Adjournment is prayed for on the ground of counsel appearing for the petition. Yes, any other matters? What are you waiting for?
My lord, item number 15, the interim order is expiring today, my lord.
15. Wait. Yes, anyone, Mr. Bose? Which matter? Mr. Bose, behind you.
I am waiting for my turn in Sharad Chatterjee. I want to place some of the facts which I never had the opportunity.
Yes, but that's the original side.
Yes. So I will wait.
No, that is.
My lord, your lordship doesn't give precedence to anyone in this
wait,
court.
please.
It's 23, my lord.
23. That's way down.
Yes, I know.
Yes,
My lord,
yes.
I'm not asking for precedence.
No, that's fine. Yes, call till 15, please.
Item number 15, Aroma Projects.
My lord, here section.
Call till 15, till 15.
Item number 11, the Incoda.
My lord, this is my application under section 11. Mr. Shatarup Banerjee, my lord, took a ground of maintainability stating, my lord, all the precondition for referring the matter to arbitration was not fulfilled. Lordship had heard him on part and has fixed today, my lord, for hearing him and thereafter me, my lord.
Yes, where is Mr. Banerjee?
He's coming, my lord.
Yes, list this matter tomorrow as learned counsel opinion for the respondent who is to argue the matter is not present in court. Next.
The same, my lord, between the same parties.
12,
My lord.
Same order. Next.
item number 13. Construction.
I appear for the
Yes.
lordship. I have raised a
My lord,
point of maintainability as to the territorial jurisdiction
On the section 11.
on the section.
What is the point?
Lordship, the point is, Lordship, the contract as well as the,
Please.
Lordship will kindly see the agreement which is annexed. It was executed at Kochi, Lordship.
You have to
And
tell me the page.
Lordship,
it starts from page 18 of the pitch.
18, Lordship.
An arbitration clause at page
This
20.
agreement made on the 30th day of October 2013 at Kochi, Lordship. And clause 51 of the notice inviting tender, the contract has that all the territorial jurisdiction shall lie at Kerala, because this was a project of the Spice Board. And
No, where is the arbitration clause? Page, clause 12.
Clause
no,
12, my lord.
clause 12 is the arbitration clause.
Where is the seat?
Lordship, the seat that your lordship, the seat is not, it says in any, under the agreement, referred to an arbitrator nominated by Spices Board. Lordship, the seat is, at the lordship, I'm handing over a copy of the notice of tender, clause 51. The seat says, The seat is Kerala. I'll just.
Very well. You come back tomorrow. All right.
Sir, I have stated in.
Yes, a learned counsel opinion for the respondent seeks to take a point of maintainability on the ground that the High Court at Calcutta is not the court within section 2 within brackets 1 within brackets small e of the 1996 Act, as the arbitration, as the agreement between the parties was executed in Kochi, KOCHI. Stop. Council submits that the arbitration clause does not point to either a seat or a venue. Stop. Next, list this matter tomorrow. Next.
Should I reserve my point or I should discuss now? That
Tomorrow, come back tomorrow. Next.
I don't know, 14 Sri Arunabha Saha.
Milord, I am for the petitioner,
I
Milord.
am for the respondents, my lord.
According to Milord's direction,
I can't hear you. Yes.
Milord, according to direction, last direction given on 10th August 23 to the collector for assessing the stamp duty.
It's 11.
Yes, already assessment has been made by the IGR.
The document was impounded.
Already assessment has been made and information, we have
It's
got
in
information
11.
on 1st September. The assessment is already made. 2 weeks time is required for intimation from the collector. What amount I am to deposit for instance.
So why are you saying that assessment has been made? You haven't deposited
No,
the amount.
assessment has been made by
Yes.
the IGR.
You're the advocate on record.
I'm
The advocate on record, don't use abbreviations, all right? The advocate on record, the petitioner seeks an adjournment of 2 weeks to pay the assessed amount, assessed stamp duty on the agreement. Stop, list this matter after 2
My lord,
weeks
one
as paid for.
submission, my lord. I am also seeking an extension, my lord, to file my opposition, my lord.
File it within 2 weeks.
My lord, it is, my lord, ready, my lord, I can file it.
Very
my
well.
lord,
The
by
applicant in
tomorrow.
opposition is taken on record. Reply within the returnable date.
But I am serving a copy on.
Yes, next.
I don't know, 15 Aroma projects.
One of the interim order is expiring today. One of the interim order was firstly passed on 16 January and which has been confirmed also on 6th July, rather extended on 6th July 2023. In the meantime, my lord, in the section 11 application, your lordship has been pleased to appoint an arbitrator and the arbitrator has already held her first sitting, my lord, in this matter. My lord, this is the minutes of the meeting of the first.
So then what
arbitrator.
remains
So,
of the
it's sort-
interim?
The interim
interim
order
order?
can be confirmed and matter can be now decided by
Lord,
the.
I appear of the pro forma respondents number 6 to 9, my lord.
Your lordship will find, my lord, the minutes.
So I
of
will, I will confirm it only for the next 2 weeks. When is the next sitting to be held?
The next sitting is 30th of November, my lord.
30th November.
30th November. My lord,
You bring it forward. I'm keeping it for the next 2 weeks.
my lord.
It's on you initiated the arbitration
Yes, ma'am.
claimant.
Yes,
Bring it forward. Yes,
my lord, they did not attend even despite service before the arbitrator also on the last occasion.
very well.
Pointing that out, my lord. Statement of all the directions.
The
are
learned counsel appearing for the petitioner seeks extension of an interim order passed by a coordinate bench on 16 January 2023 and continued by orders subsequent thereto, including the last order dated 6 July 2023. Stop. Council also submits that the reference has commenced in the meantime when
My lord, reference commenced 29th August was the first sitting, my lord.
that the reference commenced, that the reference has commenced on and from 29th August 2023, and the next sitting is,
It's my lord, 9th of January 2024. My lord, that's
and the next sitting is to be held on 9 January 2024. Stop. Next, since parties have already initiated the arbitration under section 9 within brackets 2 of the 1996 Act, nothing further remains of the present application under section 9 of the Act. And AP 644 of 2022 is hence, disposed of by directing the interim order dated 16 January 2023 to continue till 30th November 2023. Stop. The petitioner, the parties shall be at liberty of taking appropriate steps before the tribunal for continuing and or vacating the interim order.
Extremely obliged.
Grateful, Lordship. One of the respondents is represented. One of the respondents is represented. Yes, appellate side.
Appellate side, Delhi list item number 1, IQ City Foundation.
May I please, Your Honor?
Yes.
Volume 1.
Yes.
Lord, the dispute, Lord.
Mr. Kaur, move your microphone, please, so I can see you.
Sorry.
Yes.
Lord, the dispute essentially, Lord, arise out of a contract between the parties, namely the bank and Lord, the writ petition.
Yes.
Lord, the allegation in the writ petition is that the bank has charged interest at a rate other than the agreed rate of interest. So essentially, it's an allegation of breach of contract. Now, Lord, before I, Lord, take your lordship, Lord, to the meat of the matter, I would like to, Lord, place some of the contractual clause between the parties, because, Lord, this will be ultimately essential for adjudicating the dispute between the parties. Because, Lord, stand of the bank is that we have gone by the agreement. Whatever the terms of the agreement is concerned, we have followed that in calculating the interest. The only dispute is with regard to charging of interest.
And Mr. Kaur, you address all this in the course of your submissions. One of the other points I remember Mr. Chidambaram arguing is that all the other banks of the consortium or whatever it is, they either modified, reduced their rates, or settled with the petitioner, and you're the lone standing warrior who's kind of stuck to its guns with regard to this particular rate of interest, which the petitioner finds to be what? Unconscionable.
Unconscionable. In fact, Lord, the fact of the matter is that, Lord, so long the account remained overdue, Lord, the interest was being charged at a rate as agreed in terms of the contract. Yes. But, Lord, when they paid up very recently, till the date of filing of the writ petition, the account was overdue, both on account of the principal as well as interest. Now, after the account was made regular, then only, Lord, the bank has offered to reduce the rate of interest, but that has not been accepted because they want it retrospectively, where when the account remained overdue, they want remission for that period also. So, Lord, that also is, Lord, an attempt to unilaterally alter the contract by coming to the writ court. So
the petitioner was happy at the whatever rate you offered. The petitioner wanted a retrospective effect to that.
No, initially, when I sanctioned the loan, the rate was offered. And then, Lord, the original contract between Axis Bank and the petitioner got amended based on my agreement, the sanction. And ultimately, Lord, the default occurred. And then from year to year, there is a review of the terms and conditions, where, Lord, petitioner actively participated. I'll just take your lordships through that. I want to, my lord, place one or two documents. First, the contract to Lord, demonstrate that what are the terms. And then, Lord, I'll take your lordships through the review committee meeting because none of these documents have been placed. And Lord, the petitioners have relied upon the agreement they had entered into between themselves and Axis Bank to say that there is a breach committed by Bank of Baroda without referring to the agreement between the Bank of Baroda and the petition. So basically, my lord, I need to, my lord, show your lordships these agreements which are not relied upon by the petitioners in alleging breach.
Okay.
Now, my lord, may I just briefly, my lord, first take your lordships to the first, my lord, the page 74 of the volume, first volume. This is an agreement on which the petitioner wants to rely on.
Yes.
Lord, this is an agreement between IQ City and Axis Bank. Your lordships will find the name of the parties at page 74. My lord, Bank of Baroda is nowhere near the picture. Now, my lord, so far as Bank of Baroda is concerned, the sanction letter comes on 30th of March 2015. This agreement is 22nd November 2014. The sanction of the Bank of Baroda comes on 30th March. Please come to page 162.
Yes.
Now, my lord, kindly, my lord, see in the margin, my lord, 1, 2, 3, 4. The fifth entry, my lord, it says rate of interest. Has your lordship found that? Yes. On the left hand side? It says base rate plus 1.50%, that is 11.75% at per annum, or rate of interest being charged by Axis Bank, whichever is higher.
Yes.
Then, Lord, please also see spread reset. That's the next column. Says the lender would reserve the right to revise the spread on 31st March and every 12 months thereafter by giving 30 days prior notice to the borrower. The borrower will have the right to repay the facility in case the revised interest rate is not acceptable. Further, the lenders reserve the right to revise the spread at any date if the Reserve Bank of India, then Lord, kindly see C, credit rating of the borrower gets downgraded. A is revises the standard provisions of assets, etc., revises the risk weights for assets. Credit rating of the borrower gets downgraded. The society shall then pay interest at such reset interest rate as may be notified by the lenders to the society. Then, Lord, please come to page 173.
Yes.
This is, Lord, financial covenants, the last, Lord, clause, if your lordship sees at page 173. This is says FACR, DSCR, debt equity. FACR shall be calculated at the ratio of book value of land plus net book value of the remaining assets charged, including residual value of assets on which second charge has been provided and the outstanding under the bank facilities against the charge property. Now, Lord, vis-a-vis this, if your lordships, my lord, kindly look at page 102. The FACR here is 1.27. A lot of argument was advanced that FACR was charged at a higher rate. Kindly see 102. This is, Lord, contract between Axis Bank and the petitioner. Clause 3.2. Your lordship will find that if it says, if any time during the subsistence of this agreement, the FACR goes below 1.50 times, then the borrower shall provide and furnish to the lender to its satisfaction such additional security, etc. So, my lord, the FACR was actually lesser than Axis Bank at the stage of entering into the contract.
Yes.
Then, Lord, your lordships may also look at page 174, which talks about default interest. Kindly, my lord, see around the middle of the page. It says default interest, page 174.
Yes.
In case of any delay in repayment of principal, installment or payment of interest, charges or other monies due on the facility, default interest rate shall be levied at 2% over rate of interest from the due date till such time the overdue amount is paid. So, my lord, if there is a delay in repayment of principal or payment of interest, charges or money is due, then, my lord, 2% will be charged additionally on the rate, existing rate of interest. Now, my lord, please come to page 170.
So, Mr. Kaur, why are you showing me these clauses?
Because, my lord, there is now a dispute raised that penal interest has been charged at 2%, and Lord, 1% additionally has been charged for downgrading the credit ratings. This is what the subject matter of the dispute raised, that whether I was entitled to charge 2% penal interest and Lord 1% by reason of the downgrading of the rating.
Yes.
That is one of the challenge. And Lord, also because subsequently due to the default and downgrading, Lord, the rate of interest was changed during review meeting. And on the basis of such change in the review meeting, the rate of interest has been charged. So, Lord, whatever happened between the parties, it was all, Lord, contractually possible. And the parties agreed to the such changes. An alteration of contract took place by consent of parties. There was.
So you're saying that it can't be penal interest because the petitioner agreed to that rate of interest?
Agreed to that interest, and they also admitted, I'll show to your lordship, Lord, it is an admitted fact that they could not pay either the money that fell due or the interest thereon. So, Lord, there was an overdue on the account. During the COVID time, Lord, additional finance had to be sanctioned to square up the account under the direction of the Reserve Bank of India. And that was one time when the account was brought at par. But Lord, again, there was a default. And Lord, those defaults are all admitted. I'll show from the admitted document. These are all minutes, review meetings, where Lord, it is admitted by the petitioner that they are unable to pay. Account is overdue. They are unable to realize the money. The student's fee had to be increased for the purpose of meeting the dues of the bank. These are all, Lord, admitted documents. But I am just showing your lordships the broadly the terms under which the parties had agreed originally. Now, Lord, kindly, Lord, look at, Lord, just page 176 once, where the event of default is, Lord, explained. The last, Lord, clause at page 176.
Yes, sir.
Each of the following shall inter alia constitute an event of default. Failure to pay amount due under the facility on the relevant due date. Failure to comply with the provisions of the facility agreement, security agreement subject to 30 business days period. Breach of covenants, financial, etc. These are, Lord, spelled out. I don't want to trouble your lordships, but Lord, the contract spells out what are going to be the events of default. And then, Lord, page 181, if your lordships kindly, Lord, come to page 181, clause 22.
Yes.
This clearly spells out when the penal interest can be levied. Clause 22.
Yes.
It says penal interest will be charged under the following circumstances. One is non-payment, delayed payment, then non-payment, delayed submission of monthly stock, non-payment, delayed submission of provisional audited financials, etc. Non-payment, delayed submission of statement.
This page bears the signature of this page.
And Lord, your lordship will see the signature of the writ petitioner, which is there in the page itself.
There are two. One of IQ City, who is the other one?
The same gentleman,
Yes.
I think, one in his personal capacity, one as a director of the company.
Yes.
And my lord, please see page 182, clause 33.
Yes.
The stipulated rate of interest is subject to internal credit rating prepared by the branch and to be weighted by the sanctioning authority. The rate of interest is subject to change from time to time based on audited financials, which is to be submitted before 30th September for carrying out credit rating and deciding rate of interest to be charged in the account for the next year, effective from 1st October for the respective year, etc. In case of any delay in submission, audited financials, bank reserves the right to charge rate of interest with maximum spread along with penal interest for delay in submission. Balance sheet. So, my lord, this is broadly the terms on which, my lord, Bank of Baroda had entered into the financial transaction for 105 crores. 105 crores. 105.
What
Now,
did you say? Sorry, Mr. Kaur.
These are the terms and conditions on which
105
crores.
crores.
That was our, my lord, extent of the liability exposure. 105 crores. Now, Lord, your lordships may kindly take, Lord, one page, kindly come to page 200. Based on this agreement, the agreement between Axis Bank
Yes.
and the petitioner was amended by inducting, Lord, therein the Bank of Baroda also. Your lordships will get this at page 200 and page starts at page 200
Yes.
at 204. Your lordships will find the Bank of Baroda is included. This is called addendum number 1. And kindly, my lord, come to page 207.
Yes.
Kindly see the amendments to the loan agreement. The heading is amendments to the loan agreement.
Yes.
Please take 2.1C.
Yes.
Says the existing section 2.23 of the other terms hereby stands modified by addition of the following conditions. 9. The borrower agrees and accepts the terms and conditions of the Bank of Baroda sanction letter dated 30th March 2015. This is what I placed before your lordship at page 162.
That's the 30th March 2015 letter.
Yes, that's at page 162. I placed, Lord, the terms
Yes.
and conditions. So, Lord, this is incorporated in the agreement, which is by way of addendum 1. And your lordships will find a schedule, which is at page 207, where, Lord, the exposure of Bank of Baroda is also, Lord, mentioned. Now, your lordships may kindly, Lord, come to addendum 2, which is starts at page 212. Because, Lord, in the meantime, Syndicate Bank also, Lord,
Yes.
Lord, please come to page 212, the second addendum to the agreement.
Yes.
And your lordships will find at page 216, Syndicate Bank is also, Lord, added.
Yes.
And then your lordships will see page. Yes, we clause change.
No, so what are all this, Mr. Kaur? These are what, addenda?
This is addenda to the original agreement between Axis Bank, because original agreement between Axis Bank and the petitioner was restricted to the petitioner and the Axis Bank.
So this is addendum number 2.
Number 2.
And what was the first addendum?
That is, Lord, at page, that is at page 200. I just showed it to your lordship. That was, Lord, when Bank of Baroda was brought in. And Lord.
And now Syndicate Bank is being brought in.
Syndicate Bank is being. Now, my lord, page 221,
So 30th March 2015, Bank of Baroda was not in the picture,
not in the picture,
not in the picture.
not in the picture. They came in much later through the addendum number. Lord, 30th March 2015, we were there. And our Lord sanction was incorporated in the agreement as part of the agreement. Then Lord, please come to page 221. Your lordships will find schedule 4. Kindly see schedule 4
Yes.
says the spread which will be applicable up to Indian initial spread reset date shall be determined as follows. And this is not the spread. Bank of Baroda, the spread is also mentioned 1.50. Axis Bank 1.60, Bank of Baroda and Syndicate Bank 1.50. Now, if your lordships will kindly also take into consideration one thing, Lord, I missed out in the addendum number 1. Your lordships may kindly come to page 206 once. I'm really sorry.
That's all. Yes.
Kindly, Lord, take to definition and other terms of the agreement. Kindly come to Roman 2, II at 206.
Yes.
Nothing contained herein shall affect any of the rights of the lenders available to them under or pursuant to the loan agreement and the related finance documents against the promoter. The liability of the promoter sponsor under the related finance document shall continue to be valid and binding upon them and not in any way be affected, impaired, diluted, modified, or avoided. So, Lord, each agreement will stand alone.
Yes.
Now, Lord, so far as the addendum number 2 is concerned, kindly please come to 221. 221, I have shown your lordships, the spread. Now come to please 222. Kindly see D. The lender reserves the right to revise spread if Reserve Bank of India, etc. Kindly come to Roman 3. Any credit rating agency downgrades the loan below investment grade. So, my lord, insofar as the spread is concerned, spread can be changed under these circumstances.
And you're saying that the downgrading was is an admitted fact.
Admitted fact. I'll show from the minutes, my lord. I don't want to go into any controversy. Whatever is there on record, I shall rely on that. And Lord, please take also note of E. The borrower shall pay penal interest at the rate of 2% per annum over and above the applicable interest rate if on the defaulted amount in the event of any default in payment of interest payment, loan, any other money due and payable, etc. So, my lord, the penal interest rate was retained even after this consortium concept of consortium arrangement came into being. It is there in the sanction letter. It is there in the consortium agreement also. Now, my lord, this being the position, the loan was granted on this basis. Now, Lord, insofar as
So the loan was granted during these addenda or before the addenda were?
both before and also during, because Lord, loan was released in phases.
And
Because
the addenda kept happening.
Addenda kept
simultaneously.
happening. Yes, because originally, Lord, the liability was taken by the Axis Bank.
Yes.
Then, Lord, in the agreement, Axis Bank had a right to assign their liability. And this is by way of assignment, they assigned a part of the liability to BOB, Bank of Baroda, and Lord, part to Syndicate. And the security it was to be shared on pari passu basis. And when, Lord, the amount was defaulted, there was an accumulated arrears, then, Lord, the question of giving this additional security came up. And I'll take your lordship to that. And that they miserably failed. They did not give those securities. Additional security which they had initially agreed that they will give, they did not. But that's another story. Now, my lord, in 2016, Lord, the whatever happened in 2015 was actually reviewed in 2016. So, my lord, when this 2016 review came, if your lordships, my lord, kindly come to page 265. This is in second volume. Second volume.
What is the page?
My lord, kindly come to page 265. Kindly, my lord, see the date at the top on the right hand side, 19th of October 2016.
Yes.
It says we refer to the above, inform you that the competent authority of our bank has reviewed the following credit facility on 27 September 2016. The details of sanction, etc. stipulated. Now, my lord, please come to 266.
Yes.
Rate of interest, Lord, is mentioned. And Lord, then Lord, the spread reset is mentioned. Please come to 267. Your lordships will find the security was agreed that they will be shared pari passu between the lenders.
Yes.
Now, Lord, please turn the page 268.
Yes.
Lordships will find in bold, it is there, society to create charge on the acquired fixed asset, 96 flats for hostel purpose and 20 numbers of car parking at JD block from IQ City Infrastructure Private Limited and paid such and such.
What is society?
Society is, Lord, British Educational Society.
Yes.
I believe, Lord, they had formed it as in a trust.
Yes.
Now, Lord, this proposal of additional security came about because of page 262. Your lordships may kindly, Lord, note the page where, Lord, 262, where the company, the petitioner, by a letter of 25th September 2016, proposed that they would give this as an additional security.
Yes.
Now, my lord, the other terms and conditions were spelled out also. Then your lordships may kindly come to page 275.
Yes.
Your lordships will find
Yes.
penal interest
Yes.
around the middle of the page after clause 21. My lord will find penal interest at 1% will be charged under the following circumstances. And last bullet point is non-compliance of terms and conditions.
Yes.
So 2% plot will be charged if there is a default in payment or what you in rate of interest and installment, and 1% if there is any breach of terms and conditions. And Lord, please come to page 278. 2% is reiterated.
Yes.
Default interest rate. That's the heading. 278.
Yes.
So, Lord, this is what happened in 2016. Then, Lord, in 2017, I'm sorry.
Yes. Just 1 minute.
Yes.
Yes.
Lord, please come to 281. We are in 2017 now.
Yes. Just 1 minute.
Yes, Lord.
It's an uphill task communicating with my court officers, anything.
I realize that.
এসিটা নয় আলোর কথা বলছি এইটা 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 জ্বালাবে এইটা বন্ধ করবে Yes, sorry, Mr. Kaur.
Look,
It's slightly better than the arrangement of the documents before me.
I agree. I agree. I agree. In fact,
গোপালকে জিজ্ঞেস করুন, গোপাল বলে দেবে।
Lord, while placing the document,
Yes,
I was thinking that we'll prepare a convenience volume for your lordships. Lord, incorporating all this in one compilation, and Lord, giving the pages, Lord, important pages which are relevant for this purpose, because otherwise it will be impossible for your lordship to handle these documents. They are voluminous. So, Lord, 2017, page 281.
yes.
Kindly, Lord, come to page
71,
281.
281.
I'm sorry.
Yes. I have it.
Yes, Lord, please, Lord, performance review is clause 2. I'm not troubling your lordships. If they say that the renewal hasn't come, the 5th batch couldn't be admitted and all that, your lordship need not trouble your lordship. Kindly come to page 282, security creation.
Yes.
It was decided in the last consortium meeting that creation of charge shall be done on flats purchased by IQ City Private Limited. Mr. KD has informed the bankers that they are facing an issue with respect to tenure of the lease on the land and hence obtaining permission from ADDA for tripartite agreement to create. The company also updated that the company IQ City Infrastructure has got merged into Money Square, as corporate guarantee of Money Square is already in place for the sanctioned term loan. Mr. KD requested for some more time to resolve the matter with ADDA. Subsequently, charge may be created over the flats. The bankers have asked the client to sign tripartite agreement at the earliest. So, my lord, the experiment is not going well.
No, I was trying to actually get rid of the halo around my head. Yes, yes.
Now, my lord, after 2000, this is 2017.
Yes.
Then, Lord, comes 2018. If I may just, Lord, quickly take your lordships to 2018. It is at page 285. Lord, I'm not troubling your lordships performance review and all that. Your lordships will find that it's much to be desired. Please come to clause 4 at page 286 with regard to security creation.
Mr. Kaur, let me just repeat what I understand from these documents. And you can correct me or add to what I'm saying. First is you're saying that there is no breach on your part
My lord.
of the terms of the contract in imposing a penal rate of interest.
Yes.
That's the umbrella argument. Underneath that, you're saying that the borrower, which is the petitioner before the court, agreed to whatever interest you imposed. Number 2, you're saying that there were certain conditions under which you could impose penal interest, of which you're relying on the downgradation
Yes.
of the petitioner's credit rating, which was one of the triggers, according to you.
And also default.
default.
Yes.
Number 3, you're saying that I'm actually not very clear as to how the addenda are important. Somebody coming in at, different banks coming in at different points of time. How does that take your case forward?
I tell your lordship, Lord, my learned friend appearing for the petitioner had relied upon the first agreement between the Axis Bank and Lord, the petitioner, saying that, Lord, we have committed a breach of that condition, terms and conditions of that agreement. My contention was that I was not a party to that agreement, number one. Number two, my sanction was a totally independent sanction on independent terms and conditions. And these independent terms and conditions got incorporated by Addendum 1 and Addendum 2, where, Lord, it was specifically, Lord, laid down or agreed between the parties that those conditions will apply to the borrower independent.
Yes.
So this is the reason why I showed, Lord, Addendum 1 and Addendum 2, because, Lord, parties were absolutely clear when they entered into the contract as to what would be the terms and conditions. There was no ambiguity. They understood the terms and conditions. And they also understood that, Lord, there was a default. And as a result of default, the liability or the risk of the bank has gone up. So therefore, they themselves volunteered to, Lord, put in additional security.
And how does 30th March 2015 fit into this picture, that the petitioner agreed to having those clauses changed?
30th March 2015 is my sanction.
Your sanction.
My sanction I gave on certain terms and conditions.
Yes.
This was not only accepted by the borrower, he never challenged the terms and conditions, but subsequently the other lending banks, they, by way of Addendum 1 and Addendum 2, they also accepted the terms and conditions therein. Because, Lord, in the Addendum 1 and Addendum 2, in both the addendum, my sanction letter is mentioned, and, Lord, also that clause, notwithstanding the agreement between Axis Bank and etc., the borrower will be bound by the contractual terms. So this is, Lord, broadly my submission. And, Lord, I would factually demonstrate that there was a default, there was an overdue, and till the time the writ petition was filed, this overdue remained in the account. And, Lord, the last review was in 2019. I can show to your lordships directly to 2000, take your lordship directly to 2019 instead of, Lord, going through the years. Kindly see the last document, which starts at page 295.
Mr. Kaur, you please continue till 4 o'clock. 295.
Yes, Lord.
Yes.
Let me, Lord, at least place this document.
So you have jumped how many years?
Lord, I just 1 year, because I was placing 2018 first.
Very well.
Your lordships can have a look at 2018 at page 280, 285. I just because Mr. Banerjee insists that this clause should be shown to your lordship.
This is of 2018.
Yes, 2018.
Yes. No, but it says January 18, 2017 on top.
Oh, that is, kindly see the middle of that. Just after that, it says minutes of the lenders meeting held at registered office foundation at so and so on January 18, 2018.
Very good. Yes.
Lord, please come to 286.
Yes.
Security creation. Lord, I'll just take your lordship there. It has been decided to execute a tripartite agreement between such and such to create a charge on the residential flats purchased by IQ City to accommodate its doctors. The banks have advised the client to sign tripartite agreement at the earliest. Then, Mr. So-and-so raised concern on holding back of funds under undrawn limits of the account of non-creation of DSRA. This is Debt Service Reserve Account.
Yes.
Mr. Lohia updated the member banks that they had held back limit utilization in lieu of breach in compliance of non-creation of DSRA in favor of lenders. The DSRA was stipulated in sanction once the DCCO, that is date of commencement of commercial operation, Date is announced, considering the near-term liquidity issues consequent to the non-renewal of fifth batch. Mr. So-and-so requested banks to extend time for creation of DSRA till the December 2018 and permission to draw down funds undrawn, limits to pay off the overdue interest. All the banks suggested so-and-so to clear the overdues to enable them to put up the request of extension in timeline of creation of DSRA with the respective authorities. So, my lord, that there was an overdue is.
And you said that you're saying that the overdue remained in the books.
Overdue remained in the books. Lord, I'll.
Mr. Shah? No yawning in court. Why are both of you standing up? I meant only one.
Confusion as to which Mr. Shah.
No, because both of them were yawning probably. I couldn't see. Yes.
Now, Lord, I take your lordships to 2019, Lord. I think 2018 there was another review meeting where, Lord, it was recorded that the account is irregular.
Yes.
But I come to 2019. Please come to page 295.
Once again reassured to the payment of the overdue of respective companies. A consistent default.
Lord, if your lordships, Lord, kindly looks at page 291. I'm really sorry. I
No,
missed
that's all right. Yes. 291.
290.
290.
This is the kindly, Lord, take, Lord, just above the clause number 4.
Yes.
It says Mr. Kedia,
Who is Mr. Kedia?
this representative of the petitioner, once again reassured to the payment of the overdues of respective banks.
Yes.
Lord, that there was overdue, I don't think, Lord, there can be any dispute.
Yes.
Now, Lord, 296 is the crucial document your lordships will find here. Because of the persistent default, Lord, rate of interest was changed. Your lordships may kindly take the rate of interest here.
This is what is under challenge, 296.
Yes.
Yes.
Lord, under challenge, so far as the penal interest is concerned, it is under challenge, Lord, from 2016 itself.
Yes.
But Lord, so far as rate of interest is concerned, this is challenged with regard vis-a-vis, Lord, this 2019, Lord, the reset.
Yes.
So 14.15% is the rate of interest. Your lordships may kindly take a note of that.
14.15.
Yes, because the rate of interest, Lord, it's the third column from.
Yes, yes.
Till compliance of the terms and conditions of the original sanction. Your lordships may kindly note this.
Yes.
Applicable rate of interest, etc. So that they were not complying with the original sanction, that was the basis on which this interest rate was reset.
Yes.
And your lordships will, it says, yes, original sanction, applicable rate of interest, term loan, till for perfection of security, etc. Penal rate of interest, 14.15%, as per circular. Then post compliance of terms and conditions of original sanction, it will be 12.15%. And then it says, note, the rate of interest is subject to validation of the internal rating of the borrower at CR4. In case of further downgradation of the internal rating.
So CR4 is a rating.
Credit rating 4.
Yes.
In case of further downgradation of the internal rating, interest rate to be revised accordingly as per the exact extent guidelines of our bank. Then, Lord, spread reset is again, Lord, the same clause. I don't trouble your lordships with this. Please come to, Lord, page 298. Default rate of interest is spelled out.
And spread reset provides for
The
And
further-
a chance to the borrower to
Yes.
prepay the facility in case the revised rate is not acceptable. So
Yes.
this was not done.
This was not done, never.
Yes.
Then Lord, please come to page 298.
Yes.
This also contained a default interest rate. The second last Lord on the left hand side, Lordships will find
Yes.
2% over the rate of interest. Till such time, the overdue amount is paid. Lord, penal interest is only Lord till the time the overdue interest or the overdue amount is paid. It is not Lord a recurring Lord interest rate that is charged.
And it starts from
The date of
what is
default,
the starting point of that?
date of default. Date of default till date of payment. Lord, this also, Lord, if your Lordships, please come to page 300. Kindly see the 7th bullet point under the heading specific terms and conditions.
Specific terms, that's page 300.
Yes, Lord. Just after the Lord, the table, the Lordships will find specific.
Yes,
terms.
yes, yes.
Kindly see the 7th Lord bullet point. It says the region to ensure
Yes.
security perfection to be done within 2 months from the date of sanction of review, and in the meanwhile, penal interest to be levied till perfection of security.
Yes. Mr. Kaur, that's it. How much time do you want? How much more time?
Lord, I just Lord want Lord, Lord, another 1 hour, I think, will be sufficient for the facts. And then, Lord, I want to, Lord, deal with the legal aspect of the matter. Because of course, Lord, maintainability,
What is the legal aspect, Mr. Kaur?
maintainability of the writ petition. Because the disputes are squarely, Lord, governed by the contract, arising out of the contract. So, Lord, whether such is maintainable, and Lord, also, Lord, I have a point on the Banking Regulation Act, section 21A, which says that the court will not look into the issue of interest charged by a bank. And Lord, there are few judgments on that I want to rely on. And of course, Lord, this
That the court will not look at the issue of interest charged, provided it's a contractual dispute,
contract.
not if it's a.
Not, of course, Lord,
Yes.
if it is an unconscionable thing, I can't say that Article 14 will not enable the court to look into it. But Lord, when it is purely a contractual dispute arising out of the contract, whether your Lordships will exercise your Lordship's discretion. This is the issue.
Very well. So maintainability on that count.
On vis-a-vis that. So Lord, may I come back, Lord, on a
Yes,
date?
I will just tell you the date. It a partner. Mr. Kaur, 11th or 18th? Mr. Chidambaram will be appearing online, so that's fine. I'm told that there are already 4 matters on the 11th.
Oh, then Lord, 18th, if that
18th.
is suitable to you.
18th? Mr. Shah? Mr. Chidambaram, 18th.
I'm only listening to him virtually, my lord, on that day. Therefore, it's all right, whatever his date's convenient to the court.
Learned counsel appearing for the respondent number 1.
No, Lord, yes, respond number 1.
Respondent number 1. Respondent number 1 will continue with his submissions on 18th September 2023. Apart from those 2 points, Mr. Court, what was the other point? The penal interest and the borrower agreeing to the terms, and what was the third point?
Lord, the third point was, the third point was that, Lord, one is, Lord, that the contractual rate has been charged. There is no breach so far as the contractual rate is concerned.
Yes.
The other is, Lord, the borrower had accepted the terms and conditions
Yes.
also.
The essence of the arguments made today is that the respondent number 1 is not in breach of the contractual terms with regard to the on the question of the penal rate of interest charged, semicolon. It is also submitted that the borrower / petitioner before the court agreed to the rates of interest charged, stop. Counsel also points to the conditions on which penal interest could be charged under the terms of the contract, which includes downgradation of the petitioner's credit rating, stop. It is submitted that the petitioner's credit rating, it is submitted that the downgradation was one of the issues, was one of the reasons for charging of the penal rate of interest. Stop. Next, counsel will argue. Counsel proposes to argue on the maintainability of the writ petition on the next date.
Lord, both default and downgradation.
যেখানে বললাম downgradation and default.
And security imperfection also.
Downgradation, comma, default and security imperfection.
I'm much.
Thank you.